all of us have responded positively. Allow me to take this opportunity to welcome all of us to the inaugural Reproductive Justice Litigation Baraza. We have a number of dignitaries from African countries. We have representatives from Nigeria, South Africa, Malawi, Zimbabwe, Uganda, and Kenya. Pardon me if I've left out any country, and we'll be able to talk about it in the course of the Baraza. We recognize the presence of justices of different courts of law in the region. We have justices from the Constitutional Court of Uganda. We'll hear from them in the introductions. I don't want to miss any name. We'll have justices from the High Court of Malawi. We have justices from the High Court of Uganda, but also we have our colleagues from the magistrate courts in Uganda. They are among us. We have the academia. We have civil society organizations. We have litigants in the region. We have students, media, medical practitioners, policy people, among others. But we have a session for introductions. Abortion cases and inclusiveness of African jurisprudence by Dr. Maria Nassali, among others. So that will be the day, and in case of any adjustments, we'll be able to communicate. Without taking a lot of time, we'll directly go into the introductions and the expectations. I think it is just that I start. I did it deliberately to introduce myself first, and then I will hear from the rest of the participants. I'm Sereko Ibrahim. I'm a lawyer. I chair the Health and the Law Cluster of Uganda Law Society, and I work with Afya na Haki Institute as the head of advocacy capacity enhancement. I'm happy to be the facilitator for this regional Baraza. Thank you. Some call me MC. I don't want to dictate the order of introductions. I don't know which table we should start with. Deborah has directed me this side, so you can say a name and institution, and if you feel there's any other thing you want to share, kindly go ahead. Welcome.
I'm Ben Twinomugisha. I teach law at Makerere University. My name is Mandala Mambulasa. I'm a judge of the High Court of Malawi, Principal Registrar, Civil Division in Blantyre.
Welcome.
Good morning. My name is Godfrey Kangaude, and I work with Nyali Institute, an NGO in Malawi. Thank you.
Welcome.
Good morning. My name is Tambudzai Manjonjo. I work with the Southern Africa Litigation Center in South Africa.
Welcome.
Good morning. My name is Moses Mulumba, and I work with Afya na Haki. Thank you so much.
Morning, everyone. My name is Martin Onyango. I work with the Center for Reproductive Rights, the Africa Regional Office based in Nairobi.
Welcome.
Good morning, everyone. My name is Edin Tege, and I'm a social media influencer.
Welcome.
A very good morning to us all. Dorothy Amron is my name. I work with Center for Health, Human Rights and Development. Very welcome.
You're welcome.
Good morning, everyone. I am Ajalo Ruth, and I work with the Center for Health, Human Rights and Development.
Good morning, everyone. My name is Kenneth Stebavi. I work with the Springs Public Interest Hub.
Good morning, everyone. I am Tracy Rita Achola. I work with Center for Health, Human Rights and Development.
Good morning. My name is Anne Lumbasi, and I work with the Center for Health, Human Rights and Development.
Good morning, everyone. My name is Jessica Oga. I am a lawyer and a PhD fellow at Afiana Haki. I am from Lagos, Nigeria. Thank you.
Morning, everyone. Deogratius Mala from the East Africa Nation Media Group.
Good morning, everyone. My name is Molly Nkosi. I'm a fellow at Afiana Haki, and I am from Malawi. Thank you.
Good morning, everyone. My name is Sharon Pamela Lenny. I work with Afiana Haki. It's a pleasure to have you all.
Good morning, everyone. My name is Zam Sali, PR, School of Law, Makerere University.
Welcome.
Good morning, all. My name is Maxine Tushche. I work with the Human Rights and Peace Center.
Good morning, all. My name is Joel Osekeny. I'm with Europec.
A very good morning to us all. My name is Nachivoka Nurmusisi. I come in from the Center for Health, Human Rights and Development. Thank you.
Welcome.
Good morning to you all. My name is Asha Mwanga. I work with the Islamic Women's Initiative for Justice, Law and Peace. Thank you.
Yes, good morning. My name is Betty Balisalamu. I work with an organization called Women with a Mission. Thank you.
Good morning, everyone. I'm Casemira Mariam. I work with Makerere University School of Law. Thank you.
Good morning, everyone. My name is Geoffrey Obo, and I work at the Human Rights and Peace Center as a fellow.
Good morning, everyone. I teach law at Makerere University. I'm Businje Kabumba.
Welcome.
Good morning, everyone. I'm Nimrod Muhumuza, and I'm a researcher with Afiana Haki.
Morning, esteemed participants. I'm Batema NDA, Senior Resident Jaji Ganga. I'm fondly known as Sister Batema.
You're welcome, Sister Batema.
Yes, good morning, colleagues. My name is Anthony Kakoza. I teach law at School of Law, Makerere University.
You're welcome.
Good morning, ladies and gentlemen. My name is Matanda Abubeka. I work with the Uganda Judiciary, now as a magistrate grade 1, deployed at Shibuku Magistrates Court.
Welcome.
Good morning, everyone. My name is Maseruka Andrew, and I work with Afiana Haki. Thank you.
You're welcome, Mr. Maseruka. I think this first table.
Good morning, everyone. My name is Deborah Mwase. I work with Katwe Sisterhood in Zimbabwe.
Good morning, everyone. I'm Hilda Maumucha. I work with Women and Law in Southern Africa, Zimbabwe.
Morning, everyone. My name is Shamiso Masokovere Magoko. I work for the Children's Legal Aid Clinic in Zimbabwe. Thank you.
You're welcome. I think we have heard from every one of us.
Good morning, everybody. I'm still here. My name is Susan Okalang. I'm a High Court judge in Uganda.
My apologies, my lord. It was not deliberate. So thank you so much for the kind introductions. Allow me to extend our sincere appreciation to the partners that put together this Baraza, the School of Law, Makerere University, the Human Rights Peace Center, Europec, Afiana Haki Institute. So we thank you so much for putting together this Baraza. Well, before we descend into the agenda, I would like to note that you've seen a poster, or you have seen some banners which have leader, LIDA is a program at Afya na Haki Institute. It's about litigating reproductive justice in Africa. And the objective of this program is to create an environment where Africa embraces reproductive justice through progressive, evidence-based and collaborative litigation for access to sexual reproductive health and rights in Africa. So that is LIDA. It's not a district we have in northern Uganda. So I don't want to risk having no expectation for this Baraza, so I would request each table to have a representative to give us at least one expectation for the Baraza, then we'll be going to remarks. Just volunteers. Some tables only have men. We'll mix after tea break. We need to, gender balance is critical, and gender equality is also a very fundamental pillar for SRHR. So any volunteer? Seems we all know the objective of the Baraza. We have no expectation. So I think we will just proceed. The silence is saying that we have the expectations, we have the agenda. So those are the expectations we'll have in the Baraza. So allow me to invite Mr. Geoffrey Obo from the Human Rights Peace Center to lead us in the session of welcome remarks. Mr. Obo, you are welcome.
Thank you, Ibrahim. Yes, you're all welcome for the Litigation Baraza on Sexual and Reproductive Health. My name again is Geoffrey Obo, and I'm a fellow at the Human Rights and Peace Center, HURIPEC. Yeah, you can see the banners around. It's at the School of Law, Makerere University. Yes, we shall have some welcome remarks to kick off our Reproductive Justice Baraza. And the welcome remarks will come from some of our guests. And our guests are already here and amidst us. You've heard them introduce themselves. The welcome remarks will come from, I will go through the names. First, we shall have Dr. Businje Kabumba, who is the director of the Human Rights and Peace Center at Makerere University. Then we shall have Dr. Anthony Kakoza, who will represent the Principal School of Law, Makerere University. Professor Ronald Nalwairo is not able to make it with apologies. And then also, but Dr. Anthony Kakoza is also the head of commercial law at the School of Law. Then we have Dr. Othniel Musana, the president, Association Uganda Obstetricians and Gynecologists, who will also come and give us welcome remarks. Then after that, we shall have the CEO from the Uganda Law Society. I can see he has joined us. Then we shall also have Professor Ben Twinomigisha, who is the chairman of AHAKI, Board of Trustees. Then Justice Susan Okalanyi, Judge of the High Court. And finally, to kick us off, we shall have the Honorable Justice Chiborion Barishaki, the Justice of the High Court and member of the East African Court of Justice. Yeah, at this moment, I will invite Dr. Businje Kabumba to give us his welcome remarks.
Thank you very much, Geoffrey. I think since I'm the first person to give welcoming remarks, I should go through the protocol. My Lord, Justice Chiborion Barishachi, Justice of the Court of Appeal, and a member of the East African Court of Justice. My Lord, Judge Susan Okalanyi, Judge of the High Court of Uganda. My Lord, Judge David Batema, Judge of the High Court of Uganda. My Lord, Judge Mandala Mambulasa, Judge of the High Court of Malawi. all judges and judicial officers present, Dr. Moses Mulumba, Director General of AHAKI, Dr. Anthony Kakoza, Head of the Commercial Law Department, School of Law, Makerere University, representing the Principal School of Law, Mr. Moses Okwalinga, the Chief Executive Officer of the Ghana Law Society, friends, colleagues from the academia, from civil society, fellow citizens. As has already been mentioned, I'm Businje, and I have the distinct honor and privilege at the moment, until the position is taken away, of leading the Human Rights and Peace Center at the School of Law, Makerere University. HURIPEC is especially proud to be cooperating with AFIA and AHAKI to convene this inaugural Regional Reproductive Justice Litigation Baraza. We are especially happy to do this because it is directly connected with our mission, our vision, our identity, who we are. And who we are as HURIPEC is that we are a 30-year-old department at the School of Law at Makerere, but which is also a very unique department insofar as, and I know that the head of the School of Law, Commercial Law Department might counteract this in his own way because they're also doing something now with litigation and transactional law. But HURIPEC is especially unique as being the first center in sub-Saharan Africa that is both a department at a university, especially a School of Law, but which also has an activist face. So we straddle the realm of academia and activism, and in that sense, we occupy a very unique position. And it's one that we have tried to be true to in our 30-year existence. The three things that we do at HURIPEC are teaching, research, and advocacy. It's those three things that are central to our work. And this Baraza is exactly what HURIPEC does because it combines those three things. The papers that will be presented in the course of this week are based on research. But in holding this Baraza, it's also a form of pedagogy. We learn from each other, we communicate, we dialogue, and together, the sum of the whole is greater than its parts. And finally, through this discourse and dialogue, there's also an advocacy perspective. And it's in these three senses that, as HURIPEC, really, we are most privileged to be here to host, to co-host this with AFIA, and really be a part of this over the next 3 days. So without further ado, I'd like to warmly welcome each and every one of you to this Baraza, and I look forward to learning from each and every one of you over the course of the next 3 days. Asante sana.
Yes, thank you for that welcome remarks, emphasizing the role of HURIPEC as an institution and the essence of the Baraza. Yes, right after him, we shall have Dr. Anthony Kakoza, who is representing the Principal School of Law and is the head of the Commercial Division at Makerere University School of Law.
Thank you very much, Godfrey. Good morning again to all of you. I will adopt the protocol that was presented earlier by my colleague, Dr. Businje Kavumba. In representing the Principal School of Law, Makerere University, Professor Ronin Aluwairu, I was asked to give a few of opening remarks from the School of Law. I'm pleased to be attending this Baraza, the launch of the inaugural Regional Reproductive Justice Litigation Baraza. This year, 2023, Makerere University marks 100 years in existence as one of the oldest institutions within Africa that has been steering through in the academic circles. But as it marks these 100 years, it's also transforming itself and refocusing its energies more into being a research-led institution and not just purely academic. And as my colleague, Dr. Kavumba has observed, we do quite a couple of things within that environment: advocacy, research, academia. When we look at the research dimension, research is meant to address a number of general questions. Why are we here today? What was the past like, and what can we learn from it? What can we take into the future so that the next generation would be a better world? Last but not least, what can the future generation learn from our actions of today? And most importantly, thank us for what we have done. The work of AHAKI, together with the work of HURPEC in this dimension, is about something that is common to all of us, that we all have mothers. And with the mothers that have brought us in this world, this has come through different dimensions, and they have rights, or they've had rights. Now, how do we address those rights and improve upon them? The issues of the girl child. These are the questions that we need to address and help to come up with a better future for them. So if AHAKI and HURPEC successfully address these questions, then this will be a well-utilized partnership. I thank you very much and wish you the best in the deliberations.
Thank you. Next, we shall have Dr. Othniel Musana, who is the President Association of Uganda Obstetricians and Gynecologists.
Thank you very much. I will adopt the protocol as my colleagues before have done. So it's simpler that way. It's good to see a few familiar faces here. I'm not a lawyer, I'm an obstetrician and gynecologist, a cancer specialist, but I'm also the president of the Association of Obstetricians and Gynecologists of Uganda. It's a 35-year-old body, began in 38 year now, began in 1985. And over the past few years with our partners, SEHAD, AFYANAHAKI, and a few others, we've gone into advocacy. So you may have heard us speaking a lot about abortion and its issues in Uganda, but also training. And of course, depending on the president, I'm not sure if I'm an advocate or an activist. I'm in between there. I'm still learning that trade. You may have seen me fighting for internship, the interns, the graduates who are training and working in the hospitals. However, I am proud to be here because one, I speak from experience, not just as a practitioner, but also as somebody who has suffered the ill effects of such. In 3 years, I have lost 3 dear ones. The first was my child, 28 weeks, premature, but it was born to survive. But because of negligence, and that's in a place I was working in, the child passed on 24 hours after birth. 2, the next year in the same place, still in ICU, I lost my father. He had COVID, but he did not die of COVID. He died because somebody forgot to change an oxygen pipe. Still in the same ICU. Then, of course, at the bedside was my sister. Some of you may know her. She was also a lawyer. Died last year. A young lady called Mary Machoge. She told me, let us sue the hospital. I told her, no. Big bro will take care of it, hoping I can negotiate my way into things. The next year, she died in the same ICU, on the same bed. But the problem was systemic now. We could not transfer her from the hospital to Nairobi because of a small in the country. So part of my work of advocacy, I kill the health workers, but I also try to empower them to get the resources they need. And that's why I am here. So as I do my work as a health worker, I'm conversant. 4, I've also been sued a few times. Both in the courts, but also at the medical council. Because usually people like us who are driven, you sort of cover other people's errors. And of course, you're the one who was there, so they will say, you are there. So as we start this Baraza, from a perspective of a provider who has also suffered injury within the system, but who also is fighting that same injury not to happen again, I believe that this will be a good way to start. I don't care being sued anymore because I understand it improved me as a person, but also improved my accountability I don't care suing my colleagues because I believe it also transforms them and transforms practice. In some of the cases you have seen Sehad putting in court and a few other partners, that these have transformed the way we practice, but also the way we view the rights of women and mothers. But importantly, one of the areas which is neglected, and I think that should come out clearly in this Baraza, is the adolescents. Adolescents. So as practitioners, we've ignored them because we fear to touch certain things. As the state has ignored them because of our beliefs. I also have those beliefs, but the reality is that things are happening and we must sort them out. For example, their right to contraceptives. Abortions are happening. We don't count abortions in Uganda. We've sort of covered them and just say, sepsis, infections, but women are dying from these things. And I hope that also part of the litigation agenda can focus around saving women from abortions. I think COVID exposed us, but as president of AOGU, one of the things here is our collaboration with our partners. We've been dealing with SESIMO and a few others, but also the issue of advocacy. Some of us have come out to speak because we've been injured. So we cannot keep working without speaking about the injury, but also we know that as we advocate as organizations, as partners, as collaborations, I think we will bring about the change that we need. I also intend to stand as the president of UMA because I think that's a bigger platform, whereby it covers the country, and hopefully we can bring the reproductive health agenda and also add the litigation. I liked the word strategic. Sometimes we tell our lawyers, but you pinch here, for us we shall support, we shall give you the information so that things can change. So we believe that this is a good Baraza. We will support 100%. And as AOGU, on behalf of my colleagues, we're also having a meeting in Jinja. And I want to talk about this Baraza, that there is something happening that we need to support as colleagues. Thank you very much.
Thank you very much for that testimony that you've shared with us, and that shows why this Baraza is very critical. Next, we shall have Moses Okwalinga, who is the CEO of the Uganda Law Society, to give us his opening remarks. Welcome.
Thank you very much. Good morning, everyone. Our hosts today, thank you for the invitation. My Lord, the Justice of the Court of Appeal, Justice Chaborian, Justices of Courts of Judicature, Justice Susan Okalan, Justice Vatema. Forgive me if I mess up the protocol. The Justices of the Courts of Judicature of Malawi, other Justices present in the room, colleagues from academia, Dr. Businje, Dr. Kakoza, Dr. Mulumba, our host, the team from Afia, that word always disturbs me, Afia Hanaki, and maybe colleagues, as well as colleagues from SEHAD. Distinguished guests, ladies and gentlemen. I come here this morning to represent the president of the Uganda Law Society, who passes on his regrets. He was unable to come in this morning, so he asked me to represent him. It becomes difficult for me to read a written speech after my predecessor who has spoken from the heart. But allow me read very fast the speech that was prepared by the president of the Uganda Law Society. We bring greetings from the Uganda Law Society executive, and the Secretariat of the Uganda Law Society, as well as the membership. We are glad to be here this morning as part of the Reproductive Justice Litigation Baraza hosted by Afia Nahaki in collaboration with Makerere University School of Law and URIPEC. It's a pleasure to stand before you, sorry, not as president of the Uganda Law Society, but as the CEO of the Uganda Law Society. The Uganda Law Society is not just an organization, but a personification of legal professional values and principles. It creates spaces for lawyers to commune, share knowledge, and jointly work towards the common goal of upholding justice and guaranteeing the rule of law. The society holds a weighty duty of upholding justice and ensuring substantive fortification of fundamental rights. At this juncture, I would like to spotlight critical areas of focus in our association: the strategic litigation of sexual, reproductive, and sexual rights. And health, sexual, reproductive health rights. Our profession holds the power to drive meaningful change, to dismantle unjust policies, and to challenge discriminatory policies that undermine sexual and reproductive health rights of individuals and groups. Sexual and reproductive health rights are an essential aspect of individual autonomy and dignity, and it entails the right to make informed decisions regarding one's sexual and reproductive health, access to contraceptions, family planning, among others. However, the realization of these rights is not always guaranteed, especially for historically marginalized groups, based on the out of context strategies employed for its supposed advancements. As a legal profession committed to justice, it's our duty to use litigation as part of an array of tools for championing sexual and reproductive health rights and its cause. And strategic litigation involves cautiously choosing and litigating cases that have the potential to propel systematic change which sustainably advances the protection of sexual and reproductive health rights. Through this tactic, we can challenge discriminatory laws, policies, and practices that are the periphery, that are on the periphery of the African context, and ensure that individuals can enjoy their sexual and reproductive health rights. As a legal profession, it's our duty to advocate and protect for the rights of all individuals, irrespective of gender, socioeconomic status, as well as geographical location. Our duty transcends personal gain, and it's a responsibility towards the society. Let's be reminded of our commitment to uphold truthfulness, fairness, and justice for all. In conclusion, I hope that this litigation baraza will serve as a catalyst for perpetual feats of justice and for the promotion of sexual, reproductive, and health rights. Let's unite in this noble cause as we work towards a brighter and more inclusive future for Africa. For its part, the Uganda Law Society is committed to supporting and partnering with you in this noble cause. We are available to lend our long-term experience in public interest litigation to advance the volume and strategic execution and success of all the interventions geared towards the promotion of sexual reproductive health rights. We remain steadfast in executing our mandate, and our doors are open for any form of partnerships and support. We thank you, and on behalf of Uganda Law Society, thank you again for this invitation, and we look forward to a meaningful discussion. Thank you very much.
Thank you so much. Yes, next we shall have Professor Ben Twinomgisha, who is the Chairman, Board of Trustees of AHAKI, who is our main host for this event, for the Baraza.
My Lord, the participants, you are all welcome. I'm Ben Twinomgisha. I'm both an academic and an activist. I teach law at Makerere, and I'm a chair of AHAKI, which basically, that word, that's why Swahili word, means health and justice. In English, it means health and justice. And before I give just these welcome remarks, I would request us to have a moment of silence for the millions of women who have died around the whole world due to unavoidable maternal mortality causes, including unsafe abortion. Can we have a moment of silence? At Ahaki, we focus on health, human rights, including sexual and reproductive health rights, but which we also do at SEHAD. But at Ahaki, we have what we call an Afrocentrism approach to these issues, exploring African solutions to African problems, emphasizing the agency of the African peoples, not only viewing Africans, both women and men, as victims, but we also explore their agency, how they subvert, resist, disturb oppression in the area of sexual and reproductive rights. So today morning, next day, we are going to hear about reproductive justice and various forms of reproductive injustices that women and women suffer in this continent. Africa is composed of many countries. Today, in this room, we have representatives from Eastern and Southern Africa. The presentations we shall have and the discussion shall look at reproductive justice through the whole cycle, including adolescents, young people, women, men. We shall look beyond abortion rights. Don't simply walk out of this place when you hear abortion rights. We shall look beyond abortion rights to include other aspects of reproductive injustices. I'm excited that we have judges here. You're welcome, including Justice Cheborion, who wrote the lead judgment in Petition 16, a judgment that has revolutionized the struggle for health and human rights in this country. Before that judgment, my friend, the judge from Malawi, you remember when we were working on your dissertation, the serious challenge one had in Uganda was we do not have the right to health explicitly recognized in our constitution. How then you talk about the right to health, which is non-justiciable? But the Constitutional Court, in a judgment which I call a jewel in this field of health and human rights, firmly declared that the right to health is now justiciable in this country. Clap hands for that. And we can comfortably, whether in the academia or the judiciary, firmly state that states and non-state actors can be held accountable for non-realization of their obligations to respect, protect, and fulfill rights. Given that I will be speaking, giving a keynote, I leave it at that, and I welcome you to this meeting. Thank you very much.
Thank you very much. We shall have the Honorable Justice Susan Okalany, Justice of the High Court, next.
Judge of the High Court. That is the nomenclature in the Constitution. My Lord, Justice Cheborion, allow me not to regurgitate the protocol, distinguished fellow participants, I honor you all in your respective capacities, and I warmly welcome you to this conversation. I had remarks that I had written, but after seeing Professor Kakoza, Businje, PhD, I am shy. And then I also looked at the presentation that I had. I have looked at 2 papers that have been written, and I reminded myself that I was not a presenter. I was just supposed to make remarks. I thank Ahaki for inviting me here and allowing me to be part of this noble conversation. I will comment a little bit about the area that I'm so well conversant about, and that is the reproductive justice of victims of sexual violence. I'll limit myself to that area. I was in Gulu on Thursday, interfacing with women who were victims of the northern Uganda conflict, and also women who are working with those women to try to rehabilitate them. And it didn't end so well with me after hearing their stories of failure to access justice. From that time to date, they have children, or sons and daughters, and especially sons, in their 40s, in their 30s, who are called the children of the enemy. These children, produced out of sexual slavery, are called the children of the enemy because the mothers were abducted and made pregnant by force by the LRA combatants. And the community does not want to welcome these children. The culture and tradition of the Acholi, as it is even where I come from, is that a child born to a girl who is not married becomes a member of the clan of that girl or woman. But because these are the children of the enemy, while the brothers of those ladies have welcomed the children, the sons and daughters, the question that the participants in this meeting were asking, will their children leave our children in that land? Will they? So victims of the LRA violence, sexual violence, and other atrocities committed have not received the right to remedy. Uganda is a party to several international instruments, binding and non-binding, has enacted legislation to protect women and children from sexual violence, but many victims of sexual violence are yet to realize their right to remedy in this criminal justice system that we have. Yes, we've done many positive things. We currently have ongoing SGBV special sessions. Several sessions have happened, and cases have been handled. Conviction rates are highest in this organized system of the special sessions. But that does not address the problem of failure to facilitate the police and to handle the question of the police, as well as the problem of failure to receive medical assistance. It is charged. Medical examination on Police Form 3A is expensive for victims of sexual violence. They have to pay to photocopy Police Form 3A. They have to pay to arrest the suspect. They have to pay to have their case investigated. And what does the prosecution want? Or the criminal justice system, even the courts? All we want is evidence. Evidence, evidence, evidence. As soon as they give us evidence, we don't refer them anywhere. We just say, thank you very much for testifying. That is if you have a kind judge. Otherwise, you just say, okay, next witness. So in that kind of system, are we looking at these young women who are the biggest victims of sexual violence and who are becoming the mothers of tomorrow, who have been forced to make a choice to have a child, the child of the enemy, your rapist, and then go through the expense of facilitating justice for the Republic of Uganda? I thank you.
So much for that emphatic statement. The last but not least for our welcome remarks, we shall have Honorable Justice Chiborion Barishaki, Justice of the Court of Appeal and member of the East African Court of Justice.
Good morning. Thank you, moderator, for the opportunity. I adopt the protocol that has been ably laid. And I want to thank the organizers of this Baraza for giving me the opportunity to talk to this celebrated audience. I am happy to notice that it's really regional Baraza. I've met my friend whom I met in Johannesburg. I met in Johannesburg recently, discussing similar subjects on rights. As myself, and I want to put a disclaimer from the start that the views I will be making in this Baraza will not be the views of the judiciary of Uganda. They will not be the views of the East African Court of Justice, but there will be views of Cheborion, who is a judge in both institutions. I have increasingly been drawn to appreciate the respect for sexual, reproductive health and rights which they play in the development of a country. Before this, it was just a subject. It was theory. And, but later, after training we judges of Ugandan Judiciary had here in Entebbe, a training that was on economic and social rights, and it was conducted by Professor Christopher Mbazira. We came to appreciate more, actually, the role of these rights in society. And from then, hitherto, I have noticed enhanced steps towards ensuring these rights and their enforcement. And this has been through mainly in the area I work in the courts, where the courts have now come out more clearly to give declarations, to issue orders, and even issue structural interdicts directing mainly government to do more in the area of reproductive health. I know that many of these interdicts have been respected by government, surprisingly, and it has improved the life of our mothers and daughters. I know that the budget of the Ministry of Health now in Uganda has greatly improved. But certainly this is not much. It's actually a drop in the ocean. And there's still some resistance. There's still resistance where some circles still argue that these matters are political issues. Determination of budgets, matters which should be determined by the executive and the legislature, and not judiciary. But we have remained strong and gone ahead and said, no, these are matters that even the judiciary should address. At Arusha, the partner states, when they were putting together the treaty of the East African Community, they were very careful to make sure that the court does not have human rights jurisdiction. They went around and around and made sure they shaped it in a way that there was no way. But the court has gone ahead to reread the treaty, especially Article 27.1, and found a way of giving itself at least the authority or mandate to handle human rights matters. So it is in such ways we think that we'll be able to achieve the rights respected and enjoyed by our mothers. Of course, it is through barazas like these, workshops, and talks of this nature and conversations that we'll be able to realize these rights enjoyed. So these exercises, coming to Entebbe, is not an exercise in futility. It's out of these processes that we shall be able to share ideas, take those ideas back to where we work, and be able to see how best we can see them achieved. This would be my opening remarks. I hope I will get opportunity to give my own views in good time. I thank you for this.
Thank you so much. My session is done, but before I hand over the mic, I'll request one thing. We've sat for over an hour, so the next person can first lead us in a stretch.
I think since you have proposed lead us in the stretch, you can be in the middle there. For the people attending online, you can also stretch wherever you are. Yeah.
Okay, I think we can all stand. It's simple.
Sometimes.
My stretch was never going to be that tough.
Thank you so much. Thank you so much for that interesting opportunity for us to enjoy our right to health by stretching. We thank you so much, whoever has shared those very interesting and insightful remarks. There are quite a number of emerging issues that I think we will dissect in the course of the Baraza. I don't want to repeat because I may miss out very important issues that have come up. For the countries, I missed Rwanda. I think we have representatives from Rwanda. So we have Nigeria, South Africa, Malawi, Zimbabwe, Uganda, Kenya, and Rwanda. So the East African community is fully represented. The rest of the countries are represented by those three. But online, we also have representatives from those other countries. So the entire continent at least is covered. So we'll go into our next session where we're going to hear from It has been exciting, so I'm even losing the flow of the agenda. I enjoyed the remarks and the exercise. So we'll have a presentation from Dr. Mulumba Moses. Dr. Mulumba Moses is the Director General of Afya na Haki Institute. I'll continue as I pronounce it throughout the Baraza, Afya na Haki Institute. But in short, you can say Ahaki. Ahaki. So he's a Director General of Afya na Haki Institute. He's a founder and former Executive Director of the Center for Health, Human Rights and Development. I replaced him in the position of the Chair of the Health and Law Cluster. So I'm glad to be introducing him. He's a member of the Health and Law Cluster. He's a global health rights lawyer. And he has taught law at a number of universities in the region and in Uganda and globally. So I think he's best placed to give us a synopsis of the plausible reproductive justice framework for Africa, shifting from reproductive choice to reproductive justice. Kindly join me in welcoming Dr. Mulumba Moses.
My lords, all protocol observed. I am super excited this morning to be here, but I'm also equally challenged to be speaking about a subject that is so dear to our lives. The opening remarks have been very precise, but extremely touching in all aspects. I am not giving a keynote, and when they put me in that particular slot, I even got more challenges because my professor will be later on giving a keynote, and the risk of him disagreeing with what I'm saying is very high, and I have no opportunity to respond thereafter. So, we are talking about reproductive justice within the region. I'm controlling. And I think we are touching a subject that is extremely important for our society. As a person that has been interacting with the health systems for close to 15 years and more now, I keep saying that reproduction is not a disease. And as the doctor comrade will say, it's easy to predict within the populations the needs of reproduction in society. Even then, we have failed in many ways to actually realize reproduction through the lens of justice. It's not just us, it's been historical. Reproduction has been part of society for as long as society has existed. I also want to rest your fears that the contestations that we have today are not new. These contestations on sexuality and reproduction are also equally old. And they span across cultures and geographies. But we've tried to address them. We have used cultures, we have used norms and taboos throughout history. It is just lately, or after very many years, that we decided to legislate and form policies around cultures, norms, and taboos on sexuality. The debates on these are no longer just academic, worth a peer-reviewed paper in a Q1 journal. These are issues that affect real life. They affect and determine who will access life-saving health care. And they have serious implications for the work that we do, whether academic, civil society, or judges, or private practitioners. They affect programming, they affect funding, they affect the communities that we serve. And based on this, we are increasingly finding it important to uncover the legacies, the past legacies, the history, including present-day contextual issues that affect sexual reproductive health and rights. These are important contemporary discussions to do with sexuality. We need to recognize that legal rights are important, but maybe they are not enough. And we are increasingly realizing that human rights as a framework is important, but it's also not sufficient. A few months ago, the US was struck by a Supreme Court decision where an almost settled decision on accessing abortion care in the US changed. For a very long time, and the constitutional lawyers will know this, there has been vindication of these rights through the easier rights, the reproductive rights paradigm. My right as an individual, my choice. And that was the thing. In fact, we fought so much to say in Africa, we need to adopt what the US has been doing. But the judges came up and they said this is not a settled thing. At a time when people expanded the US Constitution, they did a wrong. We can have a serious constitutional conversation on the implication of that and what it means for us. But for me, let's just take it literally, that these are not settled issues. They are issues that have been evolving. And at a risk of sounding, they call it blasphemy, I compare them to the Bible. We have the Old Testament and the New Testament. And I've not been shy to say it several times that very soon we are going to have another testament. I don't know who is writing it, but very, very, very soon there is a testament that is going to come up. When I see what is happening in church, the splitting of people and creating so many things, it looks like there is something even within the Bible that is boiling. The way the New Testament was born, probably something will be born. Now, let's look at the Bible and think about these issues. They've been evolving over years. At first, sexual reproductive health and rights were moral issues. They were religious issues. Even when judges were going to make decisions, they would consult the moralists and the religious people. And the thinking then was the fear for human nature and family creation. When morals were used at that time without laws, without policies, the intention was to suspend any human interventions in the natural process of reproduction. Maybe it was important at the time. But is it still valid to continue the conversation that we can suspend human interventions? the way we are advancing, we are even drafting laws. The one that Honorable Sarah Pend is proposing. What is the name? Assisted reproduction. My colleagues from Kenya and South Africa have been asking me that Uganda seems to be faster than Kenya now. Issues of sexual reproductive health and rights. I don't think we are the first to think about assisted reproduction. That was the first phase many years ago. It then moved from a moral conversation to a democratic conversation. And in the UK, a number of reports were undertaken. And one of them recognized the fact that every moral aspect has to be put in the law. Any private morality and immorality which is known within the law has to meet the test of popular tolerance. Popular tolerance. So, we moved away from just discussing sexual reproductive health and rights as a moral issue to actually having it as a democratic issue, where we can vote, we can have conversations. And some of that legacy was carried on. And when colonialists came here, they carried what was existing their end. We then had a phase where we introduced offenses. Offenses became the big thing of controlling sexuality, away from taboos. And eventually, we coiled from offenses to welfare. Sexual reproductive health and rights became a health welfare issue at a certain stage. And this is where population control became a big issue, that it was important for you to be sterilized, important for you to have contraception, important for you to do this and that. And as we'll be discussing, it became a big issue in the West. All the forced sterilization, the bad things that happened around that time, testing black populations with contraceptives, and the miserable issues that came with that on slaves, they sought a way to mitigate it. And human rights started. The population conferences began to discuss human rights as a mitigating factor. Privacy became an issue, choice became an issue. But some groups felt at a time, especially the black groups that had suffered forced sterilization and a lot of injustices, that human rights was just a cover. It was just covering up. And the assumption that we should begin from where we find ourselves was not sufficient. So the black movement in the US started a concept called reproductive justice. And to them, it was important to think about the injustices they had suffered as a result of this evolution of reproduction. So the right not to have a child became a conversation, but also the right to have a child and the right to parent a child. Many of these are in the context of slavery. As slaves, if they didn't want a child, you don't force them, because they were breeding human beings to increase on the slaves. But at the same time, when they felt you were black with a poor breed, you're lazy, they then forcefully sterilize you. And then if you had a child, they would forcefully take away the child because it's their property. So these guys began to think about a framework that was beyond rights, beyond the individual. It's beyond privacy. It's beyond choice. It's also systemic contextual issues that are important to be addressed. That led to reproductive justice. But reproductive justice did not receive sufficient attention. because of the blackness it had. And lately, conversations have been coming back that maybe we need to move beyond the human rights paradigm. And there are things that we need to begin addressing, that we need to think about. The injustices that have existed have to be addressed. Forced sterilization, colonization. And the question has been, is reproductive justice a theory? Is it a framework? Or is it a movement? How do we, as lawyers, make it a legal issue? Because some of the issues that are talked about in the reproductive justice framework are to do with addressing history, are to do with addressing the injustices that existed and not covering them up. So, we've been thinking, as all this was happening, one of my colleagues keeps saying that when I actually advance the evolution in that way, I also sound Eurocentric, because what I am saying was happening in Europe and the US. And Nimrod has always asked me, aren't you Eurocentric? So one of the questions has been, as all this was happening, what was happening in Africa? Didn't we have sexuality? Weren't things happening? And they said that in order for you to understand where we are today, you must understand history, such that you get to know why we are where we are. I am not a historian, and I cannot attempt at history. But a synopsis of what was happening at the time actually indicates that within our sex and sexuality, we were not static. We are not uniform. We came from different societies. But the thing that is very clear is that we treasured fertility. Human continuation was treasured for securing lineages and providing social security. Very many societies dealt with this in different ways on the African continent. And the survival of the society, just like in the European setting, depended on the mothers. I don't know how many of you have read the book of the Navagereka, but if you read that book in between the lines, she's making so many important points on the role of queen mothers through her own life. And what actually the power of the queen mother is. The power of resistance. And the role they played with that resistance, using that invisible power. I think Professor Nakanyike has also written about another queen mother that remarried after the death of one of the kings. It was never seen in society. She got married to a Mukopi. A Mukopi is one known from the lineage of the privileged. So it was unheard of, but she resisted. So the power of queen mothers and the kind of things that they are doing, when the Navagereka talks about the story of twins, and that they are her kids, one that we men are not aware of, that has not gone through the traditional initiation of children, and Nevataka come up in arms and say, we don't know them, and this and that. What does it point to? To this power, the invisible power, and reproduction. I don't have answers for it, but it shows you that Africa was not seated. There were people that held power in the context. Social norms existed, and these controlled things like premarital pregnancy. There was knowledge on contraceptives. In Zimbabwe, cannabis, the use of cannabis was big. Waist bands to prevent pregnancy in Nigeria, Malawi, Uganda was happening. People carried out abortions. They are plants that we know from our society. So not all these things are actually just Eurocentric that were introduced. On the African continent, these things were happening. Sex and sexuality is not as conservatively viewed as people want us to believe. If you became of age, in my culture, you go to an auntie as a girl, or you go to an uncle as a boy. In Namibia, sex was used as part of hospitality for visitors. Of course, I'm not underrating the abuse that was under that. But these practices were happening. Think about our dances. The tales. Sexuality was all over. The Balongo, twins. And what happens there under? All this resulted in reproduction, unwanted pregnancies, and a lot of things. How are we dealing with them? So because these were existing, Africa existed. But when we had the era of colonization setting, we had a lot of distortions, disruptions, and impositions. The health system itself, where sexual reproductive health and rights was classified as tropical medicine, because those that first came to the continent, they thought the continent was disease-ravaged, it was never civilized, and we needed salvation. Therefore, the impunity setting in my own society, it's written that chiefs were used to inject people with mercury injections to cure syphilis. It was that forceful. Read the Public Health Act, the old Public Health Act, which is not just unique to Uganda. Substantial parts of that old Public Health Act were on controlling sexuality and sexual reproductive health and rights. Read the Penal Code. Adultery, bigamy, sodomy. They became offenses. So offenses and sexual reproductive health and rights got a relationship. So I think that we need to think as litigants. We need to uncover things we've not uncovered before. And no one is going to do it. It's not for the executive. It's not for doctors. Maybe parliament, somehow. But we need to push the boundaries. As everyone talks about decolonization, what do we need to decolonize in sexual reproductive health and rights? The laws that were imposed on us, we've tried to push back on many colonial laws. The traditional gender roles, as Professor Msisi keeps saying, traditionally a doctor was a man, whether a gynecologist or whatever. In fact, he has a paper he delivered and indicated that the first female doctors are still existing. They are not long dead. But the first male doctors with specialization are gone. It's because it's much later that we realize that, hey, actually women can be doctors. And that male can be nurses. To date, you say you are meeting a nurse and it's a male nurse. It is inconceivable. And we are not challenging this sufficiently. We are leaving it to the system to address it. We currently have a big issue of naming of doctors. Some doctors are called consultants. Others are doctors special grade. Same qualifications. Same qualifications. And I'm telling people, it's a colonial issue. When you got a master's and came here as a doctor, you'd be a consultant. An African who got a master's as a doctor, and they are here, they are medical officer special grade. Now, the system has failed to actually deal with it. A consultant receives 12 million. Medical officer special grade, some of them, same experience, same qualifications, 6 million. These are issues that have existed for a long time, and unless we confront them as people that are contributing towards the health system, it's going to be very difficult. So I think that there are sins, historical sins, we've been part of. I know lawyers here that are working with civil society. We've been part of the colonial ideology. I know academics here. You have advanced the colonial ideology. I fear to talk about judges. But we have a sin. We have a sin. And unless we address that sin, the systems are not going to change. We are all dressed in the moral mind, in the religious mind. And I keep telling people, Christianity is important, and I'm a Christian and I respect it. But it's part of culture in the UK. The same way we have culture here. Islam is important, but it's part of culture in the Arab world. Where is our culture? And we are looking for the good things. Someone is going to say, your culture was barbaric, was this. I agree, for a long time. But we also had bad culture in Christianity. There are things that we need to pick out, the positive narratives. And we need to engrave them on our jurisprudence and make them important. Civil society, we have been part of this. Many of the formation of civil society organizations is historical. I don't want to mention names, but when they were doing family planning, some civil society organizations were started around that time. And their missions have not focused on actually addressing social injustices, but they have focused on forcing people on family planning only. When we had forced sterilization happening, there were civil society organizations. I don't want to pronounce that word, Nimrod. You know what? Eugenics. We are part of the agenda of eugenics, historically. So we cannot begin from where we are. We need to challenge the narrative and push the boundaries, such that that historical sin is dealt with at whatever level, whether you're a private practitioner or you're a judicial officer, whatever you are. We need to address it if we are to have social justice. Population control, I've talked about it. I am not saying that we should throw away some of these agendas. I think my message is clear. The good, let's keep it. But something that is keeping us backwards and is not enhancing reproductive justice, we need to address it. We need to read history. We need to understand where some of these issues were coming from. And it's very important for our moving forward. We need a shift on the African continent. And the last years where we've been doing work, we've been re-examining the epistemic and practical implementation of sexual reproductive health and rights work. We need to retell and underline our story much more. We need to focus on documenting the positive narratives. We need to work with African institutions. If you have the East African Court of Justice, How do we inculcate reproductive justice there? If you have the African Commission, how do we have them pick interest in reproductive justice? Our national courts. We need to enable civil society groups to complement contextual issues that are African, not just pick Western agendas and focus on those without questioning. We need to empower the African individuals to make sure that things are done in the proper way that they are supposed to be done. There are a few interesting cases, and I will stop with these, that leave a lot of food for thought that have been happening. And I use the example of the difficult subject on access to safe and legal abortion. We have seen a trend where African courts are actually moving away from interpreting the law as is. They are broadening the socio-economic factors surrounding people litigating. We had a case in Kenya, which FIDA brought, and they were challenging the requirement that a medical doctor must sign on a permit for someone to get services that are to do with abortion. And I'm glad that my colleague from CRL is here, part of the people that litigated the case. They were arguing that if you require a doctor to sign, you're going to restrict many Kenyans who cannot access a medical doctor, and in that case, a gynecologist. It becomes unfair. This was not written anywhere, but the judges made a finding, and it's like a minor, for me, it sounded like a minor thing, but the fact that they highlighted that unsafe abortions in Kenya are happening in poor communities, among poor women and girls who cannot access a medical doctor, and therefore, for you to require a medical doctor rather than a qualified practitioner, could be someone lower than a doctor, would be a disservice to them. The issue in that case for me that is very important, that is very African, that is very contextual, is poverty. And recognizing that the penal code will not anticipate poverty on some of the circumstances. But how do you as a lawyer argue poverty as a ground? Dr. Kabumba. How do you argue poverty? Poverty is part of Africa. But it's not written in law books that actually some communities in Africa have poverty which is leading to this and this and that. It becomes difficult, but it's a ground. In Kenya, a similar case, a young girl got pregnant, and you have to get court permission to actually terminate. And the argument that she advanced before the judges was that she wanted to return to school. And if she had actually continued with the pregnancy, she would also be embarrassed before her friends. I'm glad my colleague from Rwanda is also here to speak about some of these experiences. And the judges pointed out that because of the need to return to school, we can grant a termination certificate. Because of the need to avoid embarrassment for these young girls, teenagers, and sometimes they are even much younger than teenagers. So some of those grounds become important. In Zimbabwe, court awarded damages for a delayed certificate that was not granted. And the court argued that, yeah, she deserved compensation because, she had gone through sexual violence, she had gone through rape, and when she really wanted to access the services, she couldn't access them. So for what she went through, she would be given damages. These are some of the issues which are coming up in judgments that we are seeing lately. What do they mean conceptually and contextually in the African perspective? And this is why really insisting on human rights as our entry gate to the courts of law could be important, but it's no longer the only reason why some of these decisions are being made. Coloniality continues to impact on us. The criminalization of some of these aspects continues to impact on us. And therefore, our thinking needs to change a bit. As I said, mine is to provoke your thinking. You may agree with me, you may disagree with me. But let's continue the conversation. Thank you so much.
Thank you, Dr. Mulumba. I think he deserves a second round of applause. Everyone, I've not seen anyone on their phone or someone who is in another world in the course of this baraza. So I think whatever is being highlighted or shared, I think it's very critical and touching. And I think we are going to have very many exciting moments through the baraza. I know some of you might have burning comments, questions, insights that you'd like to share. But we have also another very interesting presentation, which is a keynote address. And I think we need to relax a little bit through a break. So allow me to release you to go for a short break. When we return, we are going to hear from Professor Bento Mugisha. He'll be presenting to us Beyond Reproductive Rights, the critical reflections on reproductive justice in East and Southern Africa. And I'm glad that all those regions are fully represented in this baraza. So I know it's not yet time for break, but I was afraid that we are going to consume so much, yet we have so many questions, we have so many comments, there's a lot we want to share. So let's break, and then when we return, after 10 minutes, we hear from Professor Ben, then we have a panel discussion, any emerging issues, questions, and comments. Then we'll be able to share with you the next item on our program. Thank you. You can use the break to interact, network, know each other, share contacts, and have conversations ahead of the next session. Thank you. Hello. Good morning. I think we have enjoyed our tea break. For the colleagues attending virtually, I hope you also had a health break that side. In case you have any comments, questions, kindly share them in the chat. We'll have a moment where they will be addressed in the course of the sessions. So right now, we are going to have our keynote speech. You have papers in your folder. There's a paper by Professor Bentin Omugisha. So Professor Bentin Omugisha is a professor of law at Makerere University School of Law. He has authored a number of textbooks in the arena of health and the law. He pioneered the teaching of health and law in Uganda. He's the chairperson of the Board of Trustees of Afya na Haki. I think he's best positioned, based on that background, to make a keynote speech in the Inaugural Regional Litigation Baraza. Join me in welcoming Professor Ben to make his presentation.
Good morning once again. You have the paper in the folder. I usually make my presentations by your PowerPoint, but today I deliberately refused to take that route because given that we tackle emotive and controversial issues, there are times when I've been misquoted. And I told people at Haki, I am going to write a paper. Whether you want to publish it or you want to consider what, that's that. But let me write a draft paper so that whoever wants to attribute ideas to me, then they are here. Luckily enough, on the program, I have 1 hour. Please, I implore you to be patient with me. For us in the academia, we use what we call abstracts when we are publishing, so I put a summary there. And Ibra has given an introduction, but I want to first thank Ahaki really. You people have done a very good job. Dr. Murumba and team. Dr. Murumba, you have done a lot. I saw Dr. Murumba as a young boy in first year Makerere University. He is among the pioneers of the subject I started in Makerere Health and the Law. And I almost fainted with excitement when, after being part of his examination team for his doctorate, and the others were Bazungu, and in that room, when he was being awarded a doctor of laws, a doctor in what? In health sciences, when we were in Belgium. And I said, God, you are great. I just partly disagree with him on a number of issues, but that is the beauty of Ahaki. Ahaki is a place of cross-fertilization of ideas. We moved from SEHAD, which we also deal with, SEHAD, which is largely an advocacy on the praxis of these matters, and we said, let's have Ahaki, where we shall have the concept and paradigms of these issues, like we have seen what he has presented here. And I was having a chat with colleagues over tea, that you go through the various modes of production. But I don't want to bore the younger people here. It becomes a big problem. Okay? But it gives me pleasure to find that you sit with some of the judges you taught. Justice Vatema, I taught him. He's here. He was a classmate of one of the judges I have in the Supreme Court now, Justice Madrama. I also have Chibita there. I've taught for 37 years. And I encourage you to do exercises like I've been doing here. I've taught since October 1986. I have 4 children, 6 grandchildren. An old man, really, retired, and I'm only given some small contracts or when he invites me to do some little work here and there. Okay? So over 15 years ago, I will read some of these. I also taught the judge. In fact, I supervised his the master's thesis at the University of Pretoria, but I'm an old man. That's what it is. So you have the paper there, we shall move together. Over 15 years ago, I started a course, Health and the Law, at the then Faculty of Law. Some parts I will not read. Now School of Law, Makerere University. This was the only course that time in the region, I think. And I didn't have much. I was learning from my students. The students were even ahead of me. These issues we are talking about were alien. That time, I remember very few people had come from women law in Zimbabwe, then Georgetown, speaking about sexual reproductive rights, but not in a deeper fashion, like you saw Dr. Murumba doing. One of the course topics of the course is sexual and reproductive health and human rights, where students are expected to analyze these rights at the international, regional, and national levels. During discussion groups, students handle barriers to realization of these rights in a general fashion. They are introduced to controversial and emotive topics, including sexual rights and access to safe legal abortion. I call them emotive, and at times people wonder how I do this, because I'm a seriously practicing Christian, very, very active. But I do believe that I'm a pragmatic Christian who believes in contextual interpretation in some of these issues. In one of the classes, one of the students asked me a question. It seems you advocate for liberal reform, that is liberalization of abortion law. I'm among those Christians who believe that abortion should be prohibited, but should be allowed in certain circumstances. Because I do believe that when Jeremiah 1:5 was stated that I knew before you were born, the situation has changed. It's not what used to happen that time. So those are works, you see them there. As the student's question took me back, when I suggested that they intended to hold a litigation baraza on reproductive justice, I would be using RJ. That question returned to my mind, and sharply. Put it in another way, is juridical recognition of reproductive rights, including access to safe legal abortion, enough? If we have a law, like in Uganda, we have Article 22, Sub-Article 2, that says no person shall terminate the life of an unborn child except as may be authorized by law. We have gone to court. I'm part of a team that has gone to court in Petition 10 for court to direct Parliament to pass a law and explain the termination of pregnancy and where it may be allowed. You may have that law, but does that mean that every woman in need of abortion services will receive them? In order to execute the assignment, and as I was further researching on my students' question, I came up with that topic, which is Beyond Reproductive Rights, Critical Reflections on Reproductive Justice in Eastern and Southern Africa. I had been given some work by SEHAD some time back to look at adolescents and young people's sexual and reproductive rights, and some instrument that had been agreed upon by states within the region. Then I said, let me build on this to see what can be presented. Now, I said, you look at that paper, so at that page 2, you read that. Then I will go to page 3. Because page 2 is part of the introduction, and I will be moving ahead with it. We all know that WHO defines health generally as a state of complete physical, mental, and social well-being, rather than the absence of disease and infirmity. So in 23, WHO built on that and defined reproductive health as a state of complete physical, mental, social, and well-being, and not merely the absence of disease or infirmity in all matters relating to the reproductive system. Now, I give the reproductive health status in East Africa. I encourage you in your free time, from page 3 to page 5. I've tried to touch most of the countries in the region in terms of the reproductive health status, but it's characterized by a number of things: teenage pregnancy, of course, high maternal mortality rates, forced marriages, etc. I hope you have the paper. Yes, please, that's data. But one thing I want to put forward is data is collected by somebody else. So even a person who collects data may have an agenda. So some of these data may be full of biases, may be full of interests and broad agendas, as it were. That's why when we talk about secondary data, unlike primary data, where we go and interview people, either as respondents, key informants, or in focus group discussions, secondary data, we treat it with caution. So this paper, which is largely based on desk review, may not reveal much. At a later stage, individuals, organizations may get out some of the issues and go and interview. I always tell my students that statistics don't speak, but people do. If you want to talk to the respondents and get their interests, their voices and concerns, you need to meet them and see the challenges they are moving. Because you can say 20% of these women have undergone unsafe abortion. But you don't know the experiences of this person. But if you have a girl who tell you, I was raped by my father, I became pregnant, I feared coming home, and I went to a traditional birth attendant or somebody who gave me some concoctions, and I had an incomplete abortion, I reached the hospital. You get the point. The story now gives you the challenges this person has gone through. So that is up to page 4, as I said. That data, I did it. I presented it there. Because lawyers, we have a tendency of simply putting forward concepts, but we need to have this data. As I point out in this paper, Ethiopia, which now has a liberalized abortion law, almost like that of South Africa, where abortion can be accessed on demand in the first trimester. They first gave data from a public health perspective to religious leaders, to others, and that's how they had the termination of pregnancy law passed. So we need data, and I encourage you to always have that data. Yes, that's again at page 5. From page 5, the reproductive rights, I will just make a few points because Dr. Murumba has summarized some of these issues. You know, in 1994, we had the International Cairo Program, the Cairo Program of Action, the International Conference on Population and Development in Cairo. That was following the 1993 World Conference on Human Rights, where women's human rights were recognized as human rights. And human rights were viewed as interdependent, indivisible, and interrelated. Now, at this conference, they noted that women's rights must be placed at the center of all development policies. And when you read this paper, I cite what others have pointed out, that conference marked a paradigm shift from a focus on population policies to placing women's rights, including sexual and reproductive rights, at the center of all development programs. So you're going to read that history. Moses has talked about it through Mexico City, then Cairo, and we talk about CEDAW. That's the Convention on the Elimination of All Forms of Discrimination Against Women, which also emphasizes issues of sexual reproductive health and rights. At page 7, I know when I'm going to emphasize by reading. At page 7, again, I still look at the plan of action that was agreed upon at Cairo, and I cite some of the paragraphs where the concept of reproductive rights was emphasized. I also talk about the Maputo Protocol. All of us know the Maputo Protocol, not so? The protocol to the African Charter on Human and People's Rights, on the rights of women in Africa. So the Maputo Protocol, which was the first treaty in the world, specifically tackle African women's rights in an interrelated, indivisible fashion. And in Article 14(2)(c), although it did not establish abortion as a right, it talked about circumstances under which abortion may be allowed, and this includes sexual assault, rape, incest, or where the continued pregnancy endangers the mental and physical health of the mother or the life of the mother or the fetus. Unfortunately, countries like Uganda entered a reservation to this specific article. But as scholars like Professor Ngwena have argued, the mere fact that a country like Uganda entered a reservation on this article does not mean that it's not bound by other provisions of the protocol, including the right to life. If you deny a girl access to safe legal abortion services and she dies, violation of the right to life. I hope all of you, most of you are in the language of sexual reproductive rights. Eh? Eh? Is that okay? Okay. Eh? But here I'm going to read so that I emphasize these points on access to safe abortion legal regime. So the legal status of abortion in the Eastern Southern African region varies from, I'm on page 7, varies from one country to the next. In Uganda, abortion is criminalized under those sections except for saving the life of the mother. The Constitution also provides that no person has the right to terminate the life of the unborn child except as may be authorized by law. In Kenya, the Constitution provides that life of a person begins at conception in Article 26, Sub-Article 2, and abortion is not permitted. Is not permitted unless, in the opinion of a trained health professional, there is a need for emergency treatment, or the life of the mother is in danger, or if permitted by any other written law. In FIDA Kenya and others, I think Moses, you gave that case. In FIDA Kenya and others versus Ministry of Health and others, it was held that abortion is illegal. There were two FIDA cases. Is illegal in Kenya, save for the exceptions provided for under Article 26, subsection 4. In PAC and another, versus the Attorney General and others, the court held that access to abortion services is a human right, and forcing someone to carry an unwanted pregnancy to term, I'm telling you, some of these are unwanted. Like that example I've given you of a girl being impregnated by a father. I don't know whether in your countries you are having increased cases of incest. A brother impregnating a sister. And imagine Justice Cheborion. Eh? This is just imagine. Eh? Eh? You get my point? Oh, let me use myself. Eh? Yeah. So let's say, assuming a man has sex with a daughter, and this daughter becomes pregnant and confines in the mother. You see the difficult choice this mother goes through? Now I've started now. This is how I thought I would stick here. This situation which this woman, the mother, goes through, she thinks, if this girl gives birth, am I going to sit at the same table with this girl or boy who has been given birth to? Is it my daughter? Is it my granddaughter? You get my point? So the mental health, the emotional, mental health trauma and consequences which this girl goes through. And that's why regimes like these come up with those exceptions like incest. Okay? Lady is here. God forbid, assuming you have an affair, you are married, you have an extramarital affair with a white man. and you become pregnant, the product will be clear. Are you getting that? So let me go on. You get the point? You see, when we talk about these issues, we have strong Christian views, Islamic views, but when we talk about these issues, these are real issues. These are real issues. And later in the paper, you are going to hear how pre-colonial Africa was handling some of these. He has talked about it. So it's a serious matter. Eh? This woman will now tell the husband, cannot say what among, like my tribe, they say, ethnic group, they say, the child resembles you here. No, the duplicate is there. I hope you get this. Eh? Okay? Rape, marital rape. I'm not marital rape. Eh? Gang rape. A girl is walking on the streets of Lilongwe. She is raped by 5 men. She becomes pregnant. Permanent trauma. Okay? Yeah, so that case is there, you'll see it. In Tanzania, abortion is illegal, except for the preservation of the mother's life. I think across Africa, most of our constitution, there is that therapeutic defense where abortion is allowed for purposes of preserving the mother's life. So in Rwanda, 2012, amendment allows abortion in cases of rape, incest, or forced marriage. It domesticated the Maputo Protocol. At first, it had put a requirement that for you to get a termination of pregnancy, you must get a court order. And you know, in Africa, before you get a court order, you have already given birth. But thank God, in Rwanda now, they have removed that. They have now removed that, so it's a liberalized law. In Tanzania, abortion is illegal. We have seen that in Rwanda. That's the circumstance. In Mozambique, the law allows abortion on request in the first 12 weeks of pregnancy. So in Africa, we have Mozambique, we have South Africa, we have Ethiopia with really liberalized laws, but of course with serious challenges that we're going to see for South Africa. In Zimbabwe, abortion is allowed for the preservation of the woman's life or health where the fetus has physical or mental defects. And you read that. Moses Mrumba has talked about the case of Mapingure. I think I saw it there. Okay? Mapingure, the case in Zimbabwe. You read that at page 8. I know where I'm going to read verbatim, but I did this deliberately, so that if you have time, you read this, especially people who are new to this area. That's why I made the paper so detailed, so that we can know what's happening in each country. Okay? But in this case, Moses did not emphasize, let me go through it, because it has a lot of injustices, as you are going to see, but of course, handled by the court. So in Mapingure, how do you pronounce that, those of Zimbabwe? Mapingure? Mapingure. Eh? Mapingure. Eh? Hey. Versus Ministry of Home Affairs. In this case, on 40th April 2006, the plaintiff was attacked and raped by robbers. Can you imagine that in your head? Even if you are not a woman, you men, you imagine that? You are walking along the streets of your city and you are raped, not by any other person, you know what, but by robbers. She reported the case to the police and requested to be taken to a medical practitioner for emergency contraception to prevent pregnancy and any possible sexually transmitted infection. Activists in this room, do we talk about emergence of contraception when we talk about these issues? Or we talk about contraceptives? Do we talk about emergence of contraception in terms of access? So that you see, my daughters, your sisters, can, when they are walking, have the materials in their bags. Should anything happen, they throw it in. Have we thought about it? The struggle of access for emergency contraception. Later in the day, she was taken, again, as I read this paper, point out areas, potential areas of litigation. Okay? Later in the day, she was taken to hospital and attended by a medical practitioner who said that she would only grant her request for emergency contraception in the presence of a police officer. Imagine, in the presence of a police what? Officer. confidentiality, privacy, all that. The medical officer also informed her that the medication could only be administered within 72 hours of occurrence of the sexual intercourse. Next day, the plaintiff went to the police and she was told that the police officer responsible was out of station. On 7th April 2006, she reported the hospital with another police officer. And let me tell you, if a woman or girl has decided to terminate, changing that decision is not easy. You must move beyond her face to know why she's doing it. You know, at times we are quick to judge, but we don't go behind to see why is this woman terminating. A woman who has carried a pregnancy would like to carry this pregnancy and have a child, but why? You get the point? A good number have those reasons, which some of us who are quick to judge do not consider. But you see this how this girl, the lady, is tossed around. The medical officer informed her that since the 72 hours had elapsed, she could not receive the necessary treatment. On 5th May, the plaintiff was confirmed pregnant. When she approached the investigating officer, she was referred to a public prosecutor who informed her that she had to wait until the rape trial had been completed, that wait until the court has finished its business. She had to wait until the rape trial had been completed before termination of the pregnancy. In July, the prosecutor informed her that she needed a pregnancy termination order from the magistrate, because that's why the 1977 Act provides. And I always tell my students in the class, really imagine, you are under that apprehension, you want to have this termination out, the law, which they call an us, allows it, but here you are being tossed around. On 30th September 2006, so I want you to go back to your laws, study them, and see whether they have those inbuilt delays that may even deny the women rights that they could have had in this situation. Okay? On September 30th, she obtained the relevant magisterial certificate, but when she saw termination of pregnancy from hospital, she was informed that it was risky to carry out the procedure because it had reached those advanced months where they may not do that. The plaintiff sued in the High Court of Zimbabwe against the defendants for damages for pain and suffering occasioned her and the maintenance of the child. She argued that the defendants' employees were negligent in their failure to prevent the pregnancy and or facilitate its termination. The court dismissed her claim and held that she was simply ignorant of the correct procedure to follow, that the relevant officers were under no legal duty to advise her, and the defendants were thus neither directly nor vicariously liable. The plaintiff appealed to the Supreme Court, and the court held that the police breached their duty to assist their parent in accessing timely services in order to prevent pregnancy. That the medical practitioner failed to perform his professional duty to avoid the pregnancy, and it granted the apparent damages. Now, within strategic litigation, a case like this, if it happened like in Uganda, Kenya, or others, you may decide to move it beyond negligence, because proving negligence is not easy. We know the Donog versus Stephen standard, duty of care, breach of the duty, and damages. But what SEHAD has been doing, for example, is strategically, not only not focus on medical negligence, but to go to constitutional rights and their enforcement, and say that by doing this, they subjected the woman to cruel, inhuman, and degrading treatment. You get the point? So that you see, you raise the bar by getting declarations from court. That is strategic litigation. Not that you have dodged negligence, you would not have gone for negligence, you would have gone for the Dental and Practitioners Council, or some other things. So some of the cases you decide to go to the Constitutional Court or High Court, you go to High Court for enforcement of rights. I hope you get this point, Okay? Sorry when I continue asking that, because I'm a teacher, you see. Yeah. So in Zambia, abortion is only allowed where there is risk to the life of the pregnant woman, risk of injury to the physical or mental health of any existing children of the pregnant woman, greater than if the pregnancy was terminated. You know, you have to balance. You have a woman's right to life, weighing it against the right of the unborn child. Should I save the fetus who I have not seen, or should I save the mother? That's the delicate balance that has to be worked. So in Botswana, abortion is prohibited except for saving the pregnant woman's life and preserving her health, rape or incest, or defilement, or in the event of significant fetal abnormality. In Malawi, abortion is illegal except for the preservation of the life. As the situation changed, I don't know. Preservation of the life or health of the woman. Then there is that case which is instructive, almost like our 224. In the States, on application of guardian on behalf of GM versus the hospital director of Queen Elizabeth and another, the applicant on behalf of a minor sought from the High Court of Malawi an order quashing the decision of the first defendant through medical officers denying the applicant access to self-termination of pregnancy, and a declaration outlining the specific circumstances in which victims of sexual offenses and or other deserving women can access self-termination of pregnancy in terms of Justice Okalanya. This is when we talk about this sexual violence you've been talking about and you have seen it. I believe as you write judgments, as you hear these stories from these women, these girls, deep in your heart you may say, I wish the law could provide for a self-termination of pregnancy. The challenge that used to happen, people would say that they have to cut the fetus, etc. We now have misoprostol. We have other technologies that can come in to help in these issues. So this, which like Section 224 of our Penal Code, establishes the therapeutic defense for a person who performed the surgical operation on a woman in good faith and with reasonable care and skill with regard to the state of the patient at that time and the circumstances of the case in order to save her life. The judge stated, again, all this is only possible if the person willing to undergo such a procedure demonstrates how the pregnancy is detrimental to her health and life in general. The judge has put the burden now on this poor girl. On this poor girl, raped by a village mate. The father told her, if ever you become pregnant, I will kill you. This is the spear. She fears to tell the mother, because in most of African communities, if a girl becomes pregnant or sins, the sin goes to the mother. You are the one who has not brought up the child quickly. So within this mind of this girl, she's now added an extra burden of demonstrating. He who alleges must prove. Demonstrating, okay, that the pregnancy is detrimental to her health and life in general. As a judge, can't you see that, really? Colleagues, I'm sorry when I talk about judges, but they are the ones we are talking about. Litigation, that's where we go. That's where we go. Most importantly, such a lady must ask for such a decision to terminate on medical grounds following the advice of the medical practitioner. The latter makes a decision in accordance with their medical skill for the benefit of the person, if the circumstances allow it to be heard. The qualifier is that there should be a risk to the life of the mother by preserving the unborn child. The law favors the preservation of the life of the mother at the expense of the unborn child. All this provision, this defense, which all our countries got from Crown Rex versus Bone, is basically to allow the doctor to make that judgment. She's the one who has received this girl, this woman, in that debilitating fashion to see, can I perform this procedure? Okay? It can therefore be concluded that reproductive rights include those ones I have listed there. So let's go to understanding reproductive justice. Again, Moses has talked about this. Reproductive justice, a term coined by women of African descent for reproductive justice in 1994. You see, after the Cairo program, Cairo conference, these women went aside and they said, no. Let's do something, as Moses has explained here. It arose from efforts of feminist movements in the global south who advocated for recognition of sexual reproductive health and rights at the conference in Cairo. The Asian communities for reproductive health, justice have also defined RIJ as the complete physical, mental, and I like this definition, complete physical, mental, spiritual, political, social, and economic well-being of women and girls based on the full achievement and protection of women's human rights. Friends, I don't put this in this paper, but I have argued it elsewhere. Like in Uganda, where we have privatized health care, even if abortion care was liberalized and we are subjecting it to market forces, can our poor girls or women afford this type of care? Are you getting the point I'm making? Most of our countries in sub-Saharan Africa in the 1980s implemented World Bank and IMF structural adjustment programs, where the state was commanded to abdicate its responsibility to provide social and economic services. And they privatized socio-economic services, reduced labor force, etc. And they put forward the rule of the market. Capitalism as well, survival for the fittest. You have the money, you pay for health services. You don't have, you die. So even if we liberalize abortion services in the law, given the poverty which Moses has talked about, can these girls and women access it? One of the point advocacy is to advocate for free access to abortion services. Okay? According to Sister Song, this organization that built the RIJ movement, RIJ is the human right to maintain personal body integrity, have children, Moses has talked about it, 3 rights, the right to have a child, the right not to have a child, and the right to bring up a child in a safe and healthy environment. So after attending the ICPD in Cairo, 12 Afro-American women who worked in the reproductive health and rights movement introduced RIJ at a conference on healthcare reform in Chicago. Again, Moses has talked about this, the environment under which these African-American women were working, having first eugenics. Even the eugenics movement, by the way, was not only on women. Even within the disability rights movement, when I'm teaching disability rights, some women and men who had disabilities were killed as a way of, they were burdened society. Okay? They were burdened society. Okay? So the eugenic movement, the forced sterilization, some of these things I'll talk about them later by quoting examples in Namibia. So after attending this, these women worked in the reproductive health and rights movement. They introduced, so this was a pro-choice conference. I don't believe, and I agree with this lady, I don't believe that we should focus only on pro-choice or pro-life. Both sides need to learn from each other. Yesterday I was reading a piece of literature. Whenever Guttmacher, IPAS, and others throw literature to us, none of them points the potential mental health effects arising out of abortion. Yesterday I read a very good piece of literature, pro-life literature. Somebody pointing out, and with lived experience and stories. So we need to listen to some of these women, okay, who may not even want to undergo abortion. As they right to campaign for the right for the unborn child, life of an unborn child, sanctity of life. They have their own views. What's human rights about? It's about diversity of views, not so. They have their own views. Okay? So they argue that it's not enough to legalize abortion since such women may not physically, and I agree, economically access the abortion services. Indeed, the legal right to abortion is meaningless for women who cannot access it due to cost, distance to the nearest health provider, or other constraints to access and utilization of abortion services. I put there those writers. RIJ moves beyond abortion rights and recognizes other social justice issues, Moses has talked about it, such as economic justice. Economic justice. This woman cannot buy some cotton wool and other maternal health commodities. And you are telling her that she has to pay a lot of money for abortion services. We must address the economic questions, the issues of poverty. And poverty is not only lack of income. Poverty is broad, it even includes lack of democratic rights, inequitable gender relations. I don't want to go into that. According to Ross, there is a need to focus on reproductive repression, and I should even add oppression. The control and exploitation of women, girls and individuals through their bodies, sexuality, labor and reproduction, rather than a narrow focus on the right to abortion. I will not go into detail this when we talk about exploitation of labor under gender and the law, a subject I have also taught. We go deeper into what we call sexual division of labor to see how these women labor, they give domesticity, which they give, is neither recognized nor rewarded. It's not paid for, but I don't want to go that way. But that's what these people are saying. We should move just beyond access to abortion rights and go to these other broader political, economic, social, cultural, religious issues surrounding reproductive rights. RIJ is rooted in the international human rights framework and tackles experiences of reproduction through a combination of reproductive rights and social justice. Moses has talked about decoloniality. He has talked about how human rights are viewed through a Eurocentric lens. I agree. But I'm among the scholars who believe that both Afrocentrism and Eurocentrism have positive and negative aspects. And to me, they are mutually reinforcing. We should draw good things from Eurocentrism and use them. Because some aspects of human rights have been used to liberate society. We can use them. In our African point of view, we should not believe with what Asante is saying, Diop and others, who say that we must glorify and romanticize all African cultures. There are certain cultures that are retrogressive, and we must discard them. And that's why Moses is talking about positive narratives. I don't want to repeat his was like a keynote, it was the keynote address. Okay? Okay, I don't want to repeat that, but because we work together. Okay? Yes. So RIJ moves beyond the juridical conceptualization of reproductive rights and incorporates the economic, social, spiritual, and health factors that affect women's reproductive choices and decision-making ability. And again, I will not go deeper into decision-making ability, but in gender and the law, we go deeper into how the majority of rural poor and urban poor women lack control over resources. They lack voices within their own societies, but I will not go deeper into that. But it's my area because I did my doctorate in maternal health rights, and through legal, anthropological, public health, ethnographical approaches, I interacted with women over months, digging with them in the field, cooking with them, talking to them. So I went into that, but I will not go deeper into it. So you will find out that RIJ transcends the pro-choice and pro-life debates. RIJ transcends the pro-choice and pro-life debates and addresses reproductive issues across the lifespan, from childbirth, or you can say even conception, up to death. I'm going to demonstrate certain aspects that are neglected. For example, reproductive issues of the elderly, menopause, andropause for men, etc., which are neglected. We tend to focus on the 14, 49 reproductive years as if me, who is coming to 65, I'm not a man who also has sexual needs and others. Okay? But we are going to see that. Okay? So, it calls for the broadening of the reproductive rights framework to include the impact of social relations and socioeconomic conditions that affect women. Ross and Solinger correctly observe that reproductive justice is the application of the intersectionality to reproductive politics in order to achieve human rights. Intersectionality. Oxford Dictionary defines intersectionality as the network of connections between social categories such as race, class, and gender, especially where this may result in additional disadvantage or discrimination. When we talk about women, we shouldn't view women as a homogeneous category. There are challenges for marginalized and disadvantaged women in the North, in Europe, in America, etc. But women in the South, specifically now in our countries, sub-Saharan Africa, the challenges faced by our women may not be the challenges faced by the majority of women in the North and the West. When we talk about sexual division of labor, a woman or a girl here will walk 4 kilometers to fetch firewood, to fetch water, to cook on the 3 stones with all that smoke. But the majority of women in the North, there is a cooker, there is a fridge, there's a dishwasher. I get the point? Both of them wash dishes, both of them cook. But how do they cook? But that's gender and the law. When I'm teaching, that's another matter. Okay? But let's go here now. So in this vein, RJ acknowledges that women are not a homogeneous category. Each woman may have their unique experience of discrimination. Look at a woman, she's poor. She's poor from a rural background. She has a disability. She's HIV positive. Are you getting the point? You get the point? You cannot compare that with Dorothy, this lady. Here. You get my point? So when we talk about women being marginalized, which we do in many boardrooms as the elite, we forget the intersectionalities. Poverty as a variable. That's a question of class. Gender as a variable. Disability as a variable. A woman who is physically disabled being pushed on a wheelbarrow. Yes, there is a journal article I wrote, and that was one of my introductory classes. And it's a real story. She was reported in Busoga, eastern part of Uganda. Pushed on a wheelbarrow. You know a wheelbarrow? Pushed on a wheelbarrow. Pregnant. She reached the facility. The midwife said, climb. That she climbs the labor bed. Climb. How did you have sex? These women are viewed as infertile, asexual. Are you getting that? Incapable of enjoying sex. And they are even, when they provide sex, it is for ritual purposes, through our witchcraft, that if you sleep with a person, with a woman with disability, your challenges will go. So when you get such a woman, you need to unpack. She's suffering reproductive injustices. Are we together? But we cannot group her. And that's why we must move beyond the statistics. Through snowball sampling and have this woman, interview her, have her story, have her history. Are you getting that? Have her story. Are you getting that? Not her history. Her story. I think that's what we say in gender. Just you see, Sister Vatima. You know, he calls himself Sister Vatima because he's an active feminist. He even produced for us the gender what? Gender book? Gender bench book. Done a lot of work in this area. He studied in Zimbabwe, this Women in Law program, and she has done a lot. Even taught in our gender and women studies in Makerere University. I have learned a lot from him. Thank you. I've learned from my student, like I've learned from my student Burumba, so many things. Thank you people for teaching the old man. I'm very happy about this. Okay? So RJ therefore considers how variables such as race, class, sexual orientation. Now you get like that woman, she has those challenges, she's lesbian. So the stigma she's facing in HIV is extending to her as a lesbian. We cannot homogenize these women. They will be having different attributes. And that's why qualitative research, the empirical research that expects you to go down and learn from the people, not through the colonial approach only of going there with your interview question, talk to the people. No. Go there even at times when you don't have the questions. Let the grassroots people, these women, give you the questions. And through in-depth discussion, you have a story, and put a story to this face, a human face to this challenge this woman is facing. So that you don't simply come here and regurgitate 20% of the women, of maternal mortality is due to unsafe abortion. Like this statistic I put here, we must go deeper and talk to these women. And if you can get the boy who impregnated this girl, and get his story why he ran away, they will ask me bride price. I wanted to first finish school. Let's listen to them. I'm going to talk about it because we tend to view men as villains, and yet we forget that they can be active partners in reproductive choices or reproductive justice as well. Okay? So, I examined in this paper constraints realization of RIJ by focusing on two components, the right to have a child and the right not to have a child. The right to have a child is the critical component of the right to health and is recognized in the various human rights instruments. I quote the UDHR, the ICPD there. I quote, violations of the right to have a child have been considered in a number of cases concerning women's right to health. For example, I'm at page 12. In Alain da Silva Pimentel versus Brazil, you people who are engaged in this litigation of reproductive justice exercise within the area of right to health, which I have said I'm very proud to have originated a discourse about this in the country. I'm happy about it, and I thank my God for having taken me through that direction. When you go to Latin America, there is a lot of literature, not only in socioeconomic and cultural rights, but also on the right to health and its various components, including sexual and reproductive rights. A 27 weeks pregnant woman died as a result of avoidable obstetric complications related to her pregnancy, including a postpartum hemorrhage. The CEDAW committee found that the lack of appropriate maternal health services of women, that the lack of appropriate maternal health services in the state party, that's Brazil, clearly fails to meet the specific distinctive health needs and interests of women. In the Center for Health, Human Rights and Development, petition 16, which again I have to thank the Constitutional Court, the judgment, lead judgment by Justice Cheborion, which revolutionized our debate about the right to health. When I was debating my doctoral thesis, one of the professors said, is there a right to health? He wanted to fail me at that stage. But I had prepared for that question. And I came with a comparative. I spoke for about 20 minutes and all of them were looking at me. Right from South Africa to Brazil to India to what? And telling them, you see, although we don't explicitly have the right to health in our Bill of Rights in the Constitution, we have provisions in the objective, national objectives, and I'm happy the courts have said now those objectives, based on Article 8A, are now justiciable. I had cases from India explaining that. And I went down and said Article 45, which is also like in the Ghanaian Constitution, says that all rights and freedoms which are in the Bill of Rights do not exclude others. I said those others. Then I went to many other things like the saving provision, the right to life. And my professor looked at me. After the viva, he told me I now agree that there is a right to health. But you can see the difficulties we went through. Even when I was teaching younger people at that time, like Moses Murumba, even Dorothy and others, convincing them that there is something called the right to health. People knew that it's civil and political rights. These things of right to health are not there. And I'm so happy that the courts have come up in this area. And we have also again to be grateful to a professor, like Justice Cheborion cited, again one of my former students, Professor Christopher Mbazira, who had an experience in South Africa for 5 years and has led a discussion in this country on socioeconomic rights, even these structural interdicts, and we are so happy about it. You are going to meet him, he's a young man. Sorry to use the word, that's patronizing. You people, if I call somebody a young man, don't worry, because I'm a very old man. I'm an old man. 65 is not a... No, it's okay. Okay? No, the thing still works just as bottom up, but... okay, let's move on. Once in a while it works. Okay? So, then in its interpretation of Article 12.2a, the Committee on Economic, Social, Cultural Rights, I would encourage all of you in this area to go to General Comment number 14. The Constitutional Court cited many provisions for us in that view, General Comment number 14 of 2000 is on the right, the highest attainable standard of physical and mental health, because Article 12 of the International Covenant on Economic, Social, Cultural Rights provides for this right to the highest attainable standard of physical and mental health. But in 2000, the Committee on Economic, Social, Cultural Rights interpreted that right, because under the Vienna Convention and the law of treaties, some of these organs are charged with providing authoritative interpretation of the norms or principles under particular treaties. So in spite of the juridical recognition, this I'm going to read, in spite of the juridical recognition at page 12, in spite of the juridical recognition of the right to have a child, many women in sub-Saharan Africa in general, and Eastern and South Africa in particular, continue to experience reproductive injustices. They either die in the course of giving birth or suffer debilitating injuries such as obstetric fistula. When women die in the course of giving birth, we call it mortality. When they suffer injuries, we call it morbidity. The major, now obstetric fistula, you people who don't know it, is that a woman will begin, like for example, passing feces through the birth canal. You get my point? She becomes smelly. Are you following what I'm doing? How I'm demonstrating? She becomes smelly. The husband moves away. The mother-in-law say, Kalabe, look at this one. What type of woman are you? The whole place is smelly. Are we together? Terrible injustice. You see? Hey, the power of the mother-in-law. Hey, I've been telling my wife, please, when my son marries, because my 3 girls have married, and I said, when my son marries, she has married her wife. Much as you brought up this boy and you like him, please give distance and space. Hey. Or become a friend to this one here. But have you got what I was trying to demonstrate? The obstetric fistula. When we go to court, and like that constitutional judgment of petition 16, which held, among others, that by denying women access to emergency obstetric care, they are subjected to to inhuman and degrading treatment, therefore violating Article 24 and 44 of our Constitution. In this area, you must go beyond law, acquaint yourself with obstetrics, gynecology terms, and all those, so that when you go to court to argue, it becomes easier. The major complications that account for almost 75% of all maternal deaths in sub-Saharan Africa, including Southern Africa, are severe bleeding, mostly after childbirth, infections, usually after birth, high blood pressure during pregnancy. This includes preeclampsia and eclampsia, complications from delivery, and unsafe abortion. Even where maternal health services are available, some women may not access and utilize them due to numerous economic, social, or cultural constraints. There are many factors that contribute to maternal mortality and morbidity in the region, but this paper does not claim to tackle all of them. I have tackled a number of these in a number of publications. However, a review of the available literature reveals that the delay in accessing maternal health services, especially obstetric care. You see, I underline emergency obstetric care. Millions of women deliver vaginally, normally. A few develop complications, obstructed labor, and other complications, and they need an emergency. There is even a small fraction that gets what we call ectopic pregnancies, where the pregnancy moves out of the uterus and occurs, for example, in the fallopian tube. Unless that girl or woman is operated like within 1 hour or 2, she will die. She becomes a maternal health statistic in your country. These are issues you need to look at. Pick out that issue of ectopic pregnancy. We need these health centers of ours to have mini theaters or theaters, to have a doctor that can perform these types of operations. And please, women, do not misuse these facilities by going there saying that you don't want your tummy to lose, because studies have also indicated that access to cesarean care, emergency operation, is being used by some women who elect for cesarean section, even when they are not in urgent need, by fearing to push. Please do not overburden the healthcare system. Push. Yeah. Yes, you see, I'm talking about it. It's a serious issue. It's a serious issue. But of course, you see, it's the doctor to give the advice. For example, you see the dilation, you have exceeded the centimeters, your cervix cannot move on. In order to save you and the baby, they will operate you. But some of go there, please, your tummy will go back. It will enlarge, but after some time it will go back. So don't worry. Don't think of choice. Okay. In spite of the, so we are saying here now, Thaddeus and Mine, I like their work. Thaddeus, Thaddeus, Thaddeus and Main, in 1994, developed a three-delay model, and argued that if adequate treatment is provided to pregnant women, the outcome will usually be satisfactory. In other words, they put forward what they believe are 3 delays that prevent a woman from seeking care in time. 1, delay in seeking health care. The mother-in-law is saying, wait here. Our traditional birth attendant is first going to handle you. Are you getting that? Wait here. Wait here. This woman says, no, let me wait. She's fearing the hospital. Maybe the dress she has is torn. And you know, some of these women, you people, yeah, don't worry, I have got your note, but I will finish my paper, don't worry. Yeah. No, I will finish my paper. Yeah, I will finish my paper. So this woman is being detained there, delayed there, okay? And she's not moving to the hospital. Delay in arriving at the health care facility, and delay in the provision of adequate care. A pregnant woman may delay seeking care due to a number of reasons. For example, Umutesi and others found that pregnant women in Western Kenya delayed to seek care due to multi-level factors, including negative perceptions about delivery in a modern health facility, concerns with hospital delivery that are associated with cesarean delivery, which could limit future pregnancies. The author also found issues like poor sanitation, hygiene, and others. I'm taking you through these because as lawyers, I know you want the law largely. In Uganda, Jaya found that rural pregnant women's decision to seek health care was affected by distance and cost barriers. Consumables such as soap and blankets, waiting for the husband's consent for the women to leave home and seek care, etc. In 2004, I also found that many women decisions to seek health care were largely influenced by income poverty, transport costs, and affordability of care, inequitable gender relations, and a lack of control of physical and financial resources. And that these issues were also found out in Tanzania. And yes. So women may also not access and utilize skilled care due to other reasons. For example, in South Africa, pregnant adolescents may not seek skilled care due to the fear of stigma from the health workers. In Angola, informal user fees, they are still there. They deter women from seeking care. In Zambia, the evidence is there why they may not seek care. Don't worry, I departed from the usual. I had to present this paper in a multidisciplinary fashion. Pregnant, I'm at page 14. I'm about to finish. Some few more pages, like 8. Pregnant women may also delay in receiving appropriate care at the health facility due to long waiting hours, lack of money for medical charges, and disrespectful and rude communication from health workers. Women may thus be subjected to what has been termed obstetric violence. Obstetric violence, which is characterized by mistreatment, disrespect, verbal abuse, neglected care, physical abuse, and non-consented care. You can read those pieces of work. Women, their newborns or their attendants may also be detained due to inability to pay maternal health care charges. And there I give 2 cases where some patients, though they are not women, were detained. And in our countries, I don't know it is there, where some hospitals detain patients until money is paid. I don't know. In Uganda, we have seen it. Do you have it in your countries? Okay. Yeah. So these are issues, potential areas of litigation. One of the neglected issues in the discussion of reproductive justice is cancer. You see, we are focusing on abortion. When you talk about reproductive choice, reproductive justice, people's eyes are only on abortion, largely on abortion. But we have cancers, the cancer trajectory, which may adversely affect a woman's right to have a child. Many women suffer from various types of cancer, including cervical cancer, breast cancer, and ovarian cancer. Cervical cancer is the second most common cancer after breast cancer and the leading cause of death among women. Yet it is one of the most preventable of all cancers. After most of the treatment of cancer, which involves surgical removal of the uterus and or radiotherapy, a woman may not be able to be pregnant. So early cancer screening and treatment is an effective preventive method. This is an area where we need to demand accountability from the government. To what extent are they investing in cancer? What about the provision of screening, availability in rural areas, etc.? This is an area you need to look at. And it's not only just for women. Men also, we have things like penile cancer, testicular cancer, breast cancer, although it's among few men. So we have cancers that affect our reproductive system, which we need to pay attention to. Another neglected issue in RJ discourse is infertility, which has a major impact on the reproductive health of men and women. WHO defines infertility there. You read it, page 15. So you read it, it can be primary or secondary, and WHO defines that. Infertility is particularly distressing and is usually attributed to women, thereby neglecting male infertility that may be due to erectile dysfunction and parasitic infections such as filariasis. Africans consider their children to be a source of power, pride, and support, especially during old age, and are critical for purposes of family lineage. You can look at the book of John Mbiti. It has been cited by very many scholars of sexual reproductive rights, African religions, and philosophy. Thus, infertility is frowned upon in Africa, and infertile women suffer a lot of stigma and discrimination from their husbands or partners, in-laws, and the community. Even when I'm infertile, society thinks, hey, it's my wife who is infertile. These advocates, lawyers in this place, infertility is a serious challenge. As I'm going to illustrate, that's why I don't want to hurry Ibrahim, and I must finish this. You see, yes, I want you to get your minds out of the traditional things we are knowing. Infertility is very, very critical. We must champion for access to this assisted reproductive technology where it may have the positive aspects. It is here in Kampala. I don't know in other places how much it is, but very expensive. Okay? There I talk about South Africa, Namibia, in terms of forced sterilization, but infertility, I would like you to look at it. Another area that is neglected is maternal nutrition, which you look at. Then the right to not to have a child. People have a right not to have a child. You look at it. I have written the details there. The right not to have a child is one of the most controversial on page 16, controversial aspects of RJ in Africa in general and the ESA in particular, where religious and cultural practices influence the uptake of modern contraception. The major religions, that is traditional religion, Islam and Christianity, and African cultural practices, exalt the importance of having many children. And there I talk about examples of Catholics, etc., Islam, the Islamic view of contraception, you can read that. In many African settings, the existence of children was, and much as we talk about abortion and advocating for it, let's not forget these issues. In many African settings, The existence of children was and still is considered a sign of approval of ancestors or God, the larger family and the community. Motherhood was and is still celebrated in all African cultures, and it is almost taboo for married couples not to have children. According to one commentator, without procreation, marriage in traditional Africa was incomplete, and irrespective of a woman's qualities, her failure to bear children was worse than committing genocide. She has become the dead end of human life, not only for the gynecological line, but also for herself. When I pulled this book out of my shelf and I saw this, I just said, oh, seriously. I learned these things also as I was preparing this. On the importance of having children, you can read the quotation from Bita Game. In a study of the influences on modern contraception uptake in Uganda, where the fertility rate is 5.4 children per woman, and the unmet need of contraception among married women is 28%, Namanda and others found that religious leaders and mothers-in-law discouraged people from utilizing modern contraceptive methods. Page 17, you read that, page 17. This one, I'll read it. I have questions about how contraceptive devices are administered. Although some women may desire to use modern contraceptives, they may fear to do so due to perceived or actual side effects, including menstrual bleeding, irregular bleeding, weight changes, loss of libido, and sexual arousal challenges, sexual dysfunction, and vaginal dryness. Don't worry, vaginal dryness, you'll have it as you grow older, like we have seasonal impotence as men. Well, yeah, these things will happen, don't worry. But vaginal dryness, don't worry, okra, you can use they are water-based lubricants and others. It's not a serious challenge, you can now handle that. In Burundi, don't worry, that one we teach under sexual health in my class, those commodities, we'll talk about them. In Burundi, where the fertility rate is 6.4 per woman, they found that limited uptake of contraceptives by rural women due to fear of side effects. You read that, but the point I want to emphasize is Depo-Provera, which is one of the contraceptive devices used. Depo-Provera is widely used in Africa, and the reasons are clear, in spite of the side effects. Unlike the pill, which is taken per day, Depo-Provera, the woman gets the injection and waits for some months. Because of the gender relations at the community level, she finds that convenient. Controversial use of Depo-Provera and Norplant upon poor African women without adequate information on their side effects is a violation of their right to reproductive choice. Friends, when you go back to your countries, listen, put your ears on the ground. Get out of the abortion jacket. It's very important, but you see, abortion rights are not the alpha and omega. There are serious challenges also happening. Put your ears on the ground and find out these issues here. Contraceptive side effects, the question is so real that in the United States of America, pharmaceutical industries over the years have been sued in courts of law for millions of dollars in damages. That's a potential area. The right not to have a child also includes women's right to terminate a pregnancy, abortion. We have talked about that. Please read this. I give the African view. In Ghana, BRIC found that in pre-colonial Ghana, Moses has talked about that, through interviews of rural women, and that abortion was extremely rare. I don't believe in this literature that says that abortion was prevalent in pre-colonial times. It wasn't. It was extremely rare and could only be performed where pregnancy led to shame and hardship for women. In all societies in Africa, okay? There were secret performance by a group of women elders who, if a woman became pregnant, okay? You get my point? To avoid this stigma and shame, that woman would be handled. But it was not to say that it was now publicized, blah, 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 no. Yeah. It was secretly done because, as you read in this paper, the African importance attached to children was so great. It was a premium. These are controversial issues. I said abortion is emotive and controversial. Abortion was rare largely because, this one I will read. Abortion was rare largely because the African society valued children. And resurrection of the deceased was through children. In Africa, in my ethnic grouping, Bachiga, when I die, because I've left children, I have not died. I resurrect through my children. And a woman or man who doesn't have children, who has not left children, we have specific ceremonies and rituals we perform. Otherwise, when his or her ghost comes, it will be too tough to handle. And we still do it. No, this we still do it. Okay? So I don't want to be carried away by the fact that I must be a crusader of access to safe legal abortion without questioning. I question. I am one of the champions of access to safe legal abortion in certain circumstances. But this is the data. I prepared this intentionally. I'm giving you the data. Beyond what Guttmacher says, what reproductive rights, Center for Reproductive Rights says, what IPAS says. This is the data. Okay? In fact, abstinence and virginity were encouraged and highly valued. How many virgins are here? Put up your hand. A girl who became pregnant before marriage would bring shame to her family. I am acutely aware, of course, of patriarchy and like we do in gender and the law, how this was promoted for purposes of controlling women's sexuality. Matovu observed that it was crucial that girls did not lose their virginity before exchanging marital vows. A girl who was a virgin on her wedding day afforded her family a lump sum dowry price and wealth at the time of her marriage. Among the Wachig of southwestern Uganda, pregnancy out of marriage was lost. A girl, that's where I come from. A girl who became pregnant would be either thrown at Cheese Falls and die, or taken to an island in Lake Bunyonyi and left to die. But of course, you know, culture is not static, it is dynamic, and it changes over time. Both Islam and Christianity, which have become a way of life for millions of people in Africa, emphasize the sanctity of life and are opposed to induce abortion. I pray Moses, he is not here, I pray that we don't get a third testament. I told you at Ahaki, it's a place of cross-fertilization of ideas. The religions recognize the rights of the fetus as a person in respect of their stage of development. But of course, you know, for us, in sexual law, we know, like for purpose of murder, a person is after the umbilical cord has come out. In Islam, abortion without justifiable reason is a blameworthy act and is prohibited. It's haram. Abortion after encirclement of the fetus, that is after the 120th day gestation, is prohibited. However, abortion may be allowed depending on the threat of harm of the mother, the status of the pregnancy before encirclement, and the presence of fetal abnormalities that are incompatible with life. I put there, as I later illustrate when you read, that we tend to demonize religion as a barrier to access to abortion. Yet, like in Islam, there are very strong provisions that we can learn from. Why don't we engage religious leaders and cultural leaders about some of these issues? Because to me, without engaging religious or cultural leaders, this struggle for access to abortion will remain here, or will reach a very few people. Because these people reach thousands in churches, they reach thousands in mosques. We must engage these people. And Islam is a starting point. Yes, I have. I have had a chat. Where is the gentleman? I told her, yes, we teach together. I also teach together. We're teaching together at an Islamic university. I talked to some of these scholars, and they are the ones even who were leading me to these exceptions. So we need to look at that. It should be pointed out that even in countries where abortion law has been liberalized, and safe abortion still occur, and many women do not access safe abortion services. In Ethiopia, I give you examples. In South Africa, I talk about it. In South Africa, which also liberalized its abortion law, constraints to safe legal abortion remain. And our friend Professor Charles Ngwena is going to talk about this. And in South Africa, one of the challenges in non-regulation of the right to conscientious objections. I talk about all this in these papers. It is a challenge where doctors fear, or they don't perform the abortion. For the starters here, when we talk about conscientious objection, our constitution guarantees a right of freedom of conscience. And a doctor, say who is a Christian, who is a Muslim, a traditional religious practitioner, may say, I don't believe in abortion, I will not perform this abortion. Now in this paper, I clearly bring out that you are free to object. But as we have learned from Colombia, you must refer the patient to, that's in countries where abortion is legal. You must refer the woman to the nearest, to the nearest provider who can carry out the abortion, speed being of the essence. But in emergency need, where you see that the life of the woman or a girl is likely to be a wreck, if you don't terminate the pregnancy, you can't raise those Christian Islamic values. I want to get on this point. You must perform that abortion. I discussed this here, and my friend Professor Ngwena will elaborate on this. So how can realization of reproductive justice be enhanced? I say government should provide sexual reproductive health services to adolescents. The Dr. Baguma is a doctor who was from obstetrics. Has he gone? He has gone. Yeah, he talked about adolescents, and here I talk about adolescents. And in Eastern and Southern Africa, we need to hold governments accountable for not meeting their sexual reproductive rights and obligations. Please, we need to hold these governments accountable. These issues of forced marriages cannot continue. Teen marriage, pregnancies, of course the area of unsafe abortion, that's when I talk about it. But these forced marriages, what can we do as lawyers, as activists? These teenage pregnancies, what can we do? Okay? Then I talk about government should implement their regional commitments to address, questions of adolescents and young people at page 19. And I refer to a document which should look at. Ministers met in 2020, 2013 and 21, ministers in the region, and they committed to achieve certain targets in terms of promoting sexual and reproductive rights of younger people and adolescents. Then at page 20, government should ensure the AAA2, the availability, accessibility, acceptability, and quality of essential reproductive health services. And this one I will read because I want us to look at possible areas. The right to have a child requires that government should ensure maternal health equity and justice for all pregnant women. All pregnant women should be able to safely go through pregnancy, childbirth, and postpartum period. In this vein, government should correct class disparities and inequalities in maternal health care through systemic changes within the healthcare systems. Government should therefore ensure that there is a functioning public healthcare system, where in Uganda the Constitutional Court ordered that, where the poor and disadvantaged can access maternal health services, especially emergency obstetric care, as I emphasize. Reproductive technologies such as intrauterine insemination, in vitro fertilization, intracytoplasmic sperm injection. The RJ movement focuses largely on women. This may be understandable, but there I'm going to say we need also to take into account reproductive issues, health issues or needs of men, including male infertility, erectile dysfunction, to advocate for commodities that may help in this premature ejaculation, loss of libido, challenges associated with andropause, and penile cancer, prostate cancer, which is a very big challenge in this country. I don't know whether other countries have that challenge. Prostate cancer, including testing, simple testing like PSA, or even the other rectum test, the other invasive test, including even issues of knowledge. Why can't we hold government accountable for failure to provide information about these cancers, non-communicable diseases in general, this issue of foods we eat, the drinks, etc. Why don't we come up clearly to hold our governments accountable? Universal health insurance, which I talk about here. Some countries like Rwanda have effectively implemented the universal health insurance. And I'm told the documents, the policies were borrowed from Uganda and implemented in Rwanda. In Rwanda, they have implemented universal health insurance. Why can't we, our countries, have an effective health insurance? Okay. Government should also devise measures to ensure that pregnant men are transported to health centers. Transported to health centers. When I was growing up, we had what we used to call bus warrants taking us to school. Why don't we establish at health centers? And we say these pregnant women can be quickly rushed. You talk about like an ambulance like in Uganda, what we call a county level, health center 4. You provide solar power. There is a solar mobile phone where a midwife at health center 3 can ring, and you get an ambulance coming up. The money that we invest in jets and classified expenditure can come up, military expenditure, where there is even no war, can come up to cater for these. Let's hold the governments accountable without fear or favor. And I'm talking about things like simple things like ambulances, free transport system, bicycle or tricycle. You have heard of these. I've heard of in areas, hard-to-reach areas where they use tricycles, bicycles, which we can provide to these people to transport these women. So you can read those suggestions I make at page 21, which I talk about. Legal reform, I have so many suggestions there. Page 12, that again, legal reform. Engaging religious and cultural leaders, to me, this is very important. I preach in church. I engage fellowships. And at times I raise these issues. I don't believe it is something that we cannot talk about. Comprehensive sexuality education, which you are going to read about in this paper, where our judges gave us one of our judges gave us a good judgment based on the Convention on Rights of the Child. Comprehensive sexuality education in schools. But what type of comprehensive sexual education? Not the one that's going to teach our children how to be gay or lesbian, etc. No. Or how to engage in other sex, no. But we talk about age-appropriate, culturally sensitive. Are we together? But you see, this idea of saying, because I'm a Christian, practicing Christian like me, serious one, and you say a girl of 14, 15, 16, or a boy of 14, 15, 16 cannot have reproductive health commodities. And yet, it's a fact that our girls and boys are having sex at an old age. I mean, at a young age. The age of sexual debate is so low in most of these countries. I don't want to go deeper into this. Okay? Then I knew that this conference is on litigation. And I believe Haki and my colleagues, they expected me to present on litigation. I refused. I wanted to highlight these matters. That's why I have only given strategic interest litigation a paragraph. Okay? And I read it as I go. CSOs, civil society organization, you see, to me, I can give you my conclusion really. A focus on litigation in the struggle for realization of social, a focus on litigation in the struggle for realization of sexual reproductive health rights generally and reproductive justice in particular, to me, is not a panacea to reproductive injustices in our region. This should supplement modes of causing change, including lobbying advocacy. There are more radical views I have given in my professorial inaugural lecture, 2017, Maternal Health Rights, Politics and the Law. It is on the internet. My conclusion was, since government, the regime cannot provide these things, we should engage in a socially democratic movement and have a change of regime which can provide this. That's radical, but I gave it. Thank you.
Thank you, Professor Ben, for the wonderful presentation. You know, it is very hard to stop your boss, but also your teacher, but also your mentor. Sometimes it becomes hard, but I think it was worth the time. I know all of us have been noting a number of issues to raise. Like Professor said, this is a room of different approaches, different perspectives. Don't feel shy to share your position. At the end of the day, we will have a meeting of minds on the issues we are discussing. I don't know the order of the questions or comments, but whoever has a comment or a question, it's not targeting the speakers, Professor and Dr. Mulumba, but you can share your insights. And if you have a particular question for them, you can raise it, they will be able to respond. Yeah. I think South Africa is taking the lead.
So I have two questions. For me, this reproductive justice concept in this context is a bit new. So I'm still trying to sort of find my way around it. I find it's not new in terms of what's being raised. It's just maybe the issue of terminologies and theories and all of those things, because my understanding of our position or our, what can I say, you are taking everything and not just taking one thing. But when we say we are moving from choice, for me as a constituent, you know, I suppose when you're talking reproductive issues, yes, we are talking about everyone, but the people that are sort of victims more are women, right? And one of the biggest fights that we have been having is autonomy. So when we are saying we are moving from choice, are we saying that we are moving from issues of arguing for our autonomy when we are dealing with this? I hear something about I must not choose to have a cesarean section just so that I can keep my stomach. That is my choice. And I believe that it's very, very important. It's hard fought and hard won. If we are moving forward to, you know, conceptualize things differently to be more effective, we cannot undo some of the gains that we have already made. Then number two, I also hear a lot about let's move away from abortion. I'm also concerned. Why? Because we've never been in abortion. To say let's move away from it. One of the biggest issues that we've had as advocates is that when we're talking about sexual and reproductive health, we talk about everything else. Maternal health, the fistulas and things like that. But abortion is always taboo. And what we actually say when we're saying let's move away from abortion is that we are endorsing it. In fact, if you hear some of the campaigns or international campaigns are to acknowledge that abortion is healthcare, meaning we need to actually mainstream abortion within the reproductive rights or within the sexual rights. To then say, let's move away from abortion, for me, it's also backtracking and retrogressive. That's my view.
Thank you so much. I think Uganda is also, sorry for using countries, I don't want to misspell anyone's name or misstate it. Yeah.
Well, thank you. I think for me, I would go with the harmonization of both what the presenters have called Afrocentrism and Eurocentrism. Is that how they pronounce them? I suppose so. But to do this requires a lot of awareness. To harmonize customary laws with the statutory laws requires a lot of awareness. Awareness of both the people in the villages and the elites in towns. And this appears to be a very big exercise if it has to be taken. It cannot be left to government that you should create this awareness for reproductive justice to be achieved. What role would the civil society play? Because I see most of us here are from civil society. What role would they play in ensuring that we carry out this harmonization? Because many times, when you go to government, they will tell you that we are limited by funding. And this issue of funding has been a big defense. And when you analyze it critically, many times government is also genuine. They say we don't have sufficient resources to do all this work. We have the will, we are willing to do it, but we don't have sufficient resources. Some circles have said, even with the meager resources you have, put something on this aspect. But then they come up with issues and say, even issues of security, which one would you consider first? Would you want people to be bombed and then they die, or you want, first of all, to provide this and that? So I thought this is an area where maybe we can discuss and see how these very useful ideas can be carried forward and implemented. That would be.
Thank you. Kenya, then Uganda. I saw a hand from Uganda somewhere, but Kenya first.
Thank you very much, Ibrahim, and the other presenters. And thanks, Professor and Dr. Moses, for the insightful presentations. Reflecting on the presentation by Moses, I think that presentation reflects what is happening on the continent, and especially how the continent approaches access to reproductive healthcare or reproductive justice. And just riding on the comments by Tambuzai, I want to pose this to other scholars and also Moses, that don't you think that what is lacking in our context is the amplification of the positive African narratives on how they complement access to reproductive justice, and really not reinventing a new narrative from what we have been doing, adding the positive African perspectives into the current approach, which deals with the right to health, the question of discrimination from various aspects, and looking at the intersectional approach, which has largely been the current approach. And bearing in mind that Africa has a human rights consensus in the human rights framework on the continent. To Professor Ben, my comment goes towards the access to safe abortion. Looking at the Africa human rights framework, what is the academic view on abortion as a fundamental right from a continental perspective, looking at Article 14 of the Maputo Protocol? Are we talking about exceptions, or we are talking about rights with certain limitation based on certain grounds? Because that becomes important, that when you approach it as a fundamental right, not an exception for certain, in certain conditions, there are then responsibilities and obligations that then accrue to the state. And bearing in mind the grounding in the Maputo Protocol, are we talking about fundamental rights, the right to abortion? And finally, is the conversation that relates to the litigation, that do we find some positive aspects even in decisions that we think create challenges and barriers that we need to resolve? I pinpoint, for example, the CM decision in Malawi, which for the first time tries to use the exception from criminal culpability in the penal law to actually say that women in Malawi have a right to access safe abortion, and provides a procedure which is then problematic. Is it then a fair review that at times litigation gives us way forward, but it still creates challenges or barriers that we need to relitigate so that we resolve them? Or is it that litigation at times is just bad? How do we highlight what is positive in judgments without condemning the entire judgment for the negative perspectives? Thank you.
I think we have Uganda, then we get some responses, then we have another round of questions or comments. Dorothy, you had a comment.
Thank you once again. I'm truly humbled to be in this space, a wealth of information flowing through. So every day we are students of life. I think for me, my main concern is regarding the data. I think over time, when we look at the data that we share, especially the secondary sources, we have an issue of time lapses. If we are referring to, say, abortion statistics, we'll be looking at the UDH statistics of, say, 2016. And yet this is 2023. We're all aware that what is only constant is change itself. So how are we matching up to this in terms of updating our data around the areas that are pertinent to our hearts as we advocate for changes within the legal policy, but also within the social frames? Because if you're engaging different stakeholders, people want to know what is the latest data. But I'm also aware of the fact that issues to do with, say, abortion statistics, these are contested issues. And my colleague has left. Okay, he's a friend in practice, say, Dr. Musana. But oftentimes when we engage with them, they keep on raising the issue of, we are afraid of the legalities involved, of being criminalized. So how do we document some of this to be of help when we are thinking about legal reforms? Our hands are actually tied. So how do we support our brothers and sisters and others in the medical professions to give us the true analysis of face-to-face stories that they encounter in their daily practice? Because there's also burnout when Dorothy comes up every time and she's advocating for abortion. They'll be like, the usual CSO narrative. We don't paint the real scientific face to the actual scenarios that women and girls face when they're trying to attempt to access some of these very pertinent health services. And then finally, my thought is really about building a cohort of advocates right from universities. Like, maybe it's time to rethink our curriculums and what they look like. When I was in law school, human rights was not mandatory. It was choice. You choose where to go. But as I grow older, I start appreciating and feeling sorry for my colleagues that didn't do human rights as a missed opportunity. Because human rights is humanity. It's our day-to-day lived experiences. So if we're talking about the harmonization of Afrocentric and Eurocentric approaches, how do we bring it down to the curriculums? If we're talking about reproductive justice, how do we inculcate it in our health and the law? For example, courses or even the broader domestic human rights courses, to ensure that while we grow up and we take different positions at the benches, at parliament, we are not starting from adult education where these concepts are very new, but we are actually, making them more relatable too as we grow in the field of practice. Other than that, I really thank the organizers. It's a very, very eye-opening
Thank you so
Baraza.
much. I think we are going to first get responses. Then we'll have another round. We'll start from Zimbabwe, then go to Nigeria, then Uganda. We also have, the other regions should also have a benefit of sharing their feedback. So some have been points of reflection. They might not require a response, but there are those particular questions that have come up. For instance, Dr. Monoba, in your absence, there was a fundamental question of what do we mean by saying shift from reproductive choice to reproductive justice? Are we abandoning choice completely, or we are going with only justice? Are we abandoning the progress on advocacy for body autonomy, and then we are focusing on other issues? So there was that question. Then there was a question of the stomach. I think Professor just made a comment of the mode of delivery. I think it was an example. I don't think he emphasized that we should approach it in that way, but something that you can discuss over lunch, or you can even give a response to that. So, Doctor, I hope you, Professor, you noted the issues that came your way. I don't know who is willing to come first. I think, Dr. Mumba, since you presented first, it's important that you clear some of those issues. Thank you.
Thank you so much. I think it's a question to all of us, not just me. I think the whole argument around justice recognizes the existence of human rights. In fact, the reproductive justice framework builds on the human rights framework. But it argues that we need to move beyond the human rights narrative to actually also address the contextual issues, the systemic issues, the historical issues that the human rights narrative may not be addressing sufficiently. The originators of the reproductive justice framework were informed by really making sure that we build beyond what the human rights framework is talking about. And then the question on how do we add positive African narratives into the current approach, I think it is looking beyond the letter of the law. And if you think about what I was talking about earlier on, the letter of the law is built in its own history, the history of whoever introduced it to us. And the historical scene I talked about is the scene of perpetuating what was introduced to us without actually addressing other contextual issues that we need to think about. So part of it is looking at how things were done before, positively, but also the contextual issues that we currently face. If we are giving a judgment, or if you're raising an argument before the justices as a lawyer, it is incumbent on you to actually reinstate the importance of contextual issues. We've talked about poverty, we've talked about our cultures, we've talked about other aspects. I know that judgments become the law in one way or another, but how do we get these things into the law which is not yet written? On our part, we've been trying to summarize a framework on if I'm a lawyer litigating or I'm a lawyer helping with the client that has been prosecuted on sexual reproductive health and rights issues, what are sort of the positive things that I would actually look up to in a criminal case? In the same way, if I am arguing a constitutional matter as a lawyer, what are the specific unique African things that I would actually bring into the context of the constitutional court when I'm arguing? And it's fascinating that some of those issues are there. Some have been argued in cases, but they have not come out. If you're enforcing human rights beyond the enforcement legislation that we have, what are those other things that you could actually argue from an African point of view? And the examples that I gave in the Kenyan case, the Rwandan case, and the Zimbabwe case are just the start. I think there is a huge opportunity to think beyond those. But it should apply across the board. It's not to wait for judges to do things for us and expect judges to be activists through judicial activism without grounding, without enabling them. As lawyers in practice, as civil society groups, we certainly need to do our work right, and as people that are representing communities that are affected. Thank you very much.
Can you briefly comment on the harmonization of Afrocentrism and Eurocentrism as we move forward? Productive justice?
That's a tough one. You see, we can't disregard Eurocentrism and totally, but we can push back on some of the things that are continuing to perpetuate injustices in our context. Just look at some of the judicial procedures where we insist on judicial procedures at the expense of justice and throughout everyone simply because of procedures. Who started these procedures? You know? And why are these procedures really a barrier to accessing justice in Africa in this day and age? Are they the same procedures that the UK still follows? Of course, it's like touching on dogma in religion, but maybe that's what we need to do, to touch on some of these much cherished things, and also begin to ask ourselves, what was the genesis of this? What was the rationale? Is this rationale still rhyming the way it should be rhyming today? I think we don't push enough towards that. They tell you, you must dress this way, you must say this, you must do this, and you don't question it. And who will ever begin that conversation among us? Do we first have to die, the entire generation, and then we expect another generation to come and address it? I think that's what we are trying to push. It's a difficult area because people have been in practice for so many years, and that's what they are used to. And the only way to harmonize really is to begin a conversation and a bit of a pushback on it. Let's take on constitutional matters to challenge some of these things. If you've been operating in an old, the same way we are operating in a very old act on disability, a very old legislation on criminal proceedings, the same way we push back on those, it should be the same way that we push back on issues. And I've found the judiciary very interesting, where you bring a law and argue that it's colonial. They have pushed back on disability. When they are calling girls that are sexually abused as imbeciles, they pushed back. Who introduced the word an imbecile? What does imbecile mean? So, idiot. So we need to go on and fish out those things. We call people vagabonds. And the judiciary is beginning to, but it doesn't start with the judiciary. It starts with all of us. And we meet along the way. And then we are able to push back. I don't know whether that's a balance in any way.
Thank you, Doctor. I'm just waiting for a day when someone puts on their traditional wear and they appear before court. You know what Justice Batema can do. He'll give us a comment during the panel. I think let's give him a minute to comment on that before we hear from Professor Ben. We are going to hear from Mita Mzai after.
Okay, I'm sorry. I'm very sorry. I'm hogging the microphone. I took an opportunity. I hear you. I'm still not clear what Afrocentric versus Eurocentric is in our context. Because when we are talking Africa, the classic understanding, when I hear let's be Afrocentric, I hear patriarchy. I hear let's go back to our African values, the way that the African Union people have been pushing these days. The African values from that viewpoint is very oppressive towards me as a woman in the other rights that we have done. What is being Afrocentric in this context? From what you are saying, it's still not 100% clear. You are saying, I hear as if you are saying it's more about decoloniality, right? Let's decolonize. Let's move away from the typical stuff that we inherited that doesn't work for us. But I think it needs to be clearer, because who defines Africanness? Professor Ngwene has a whole book on Africanness. It's very important for messaging as well, because we're litigating in this as well. And if we're coming up with a framework, as you say, that framework has to be clear that this is what it is. And as Martin has said, we may not have sat down and written about it, but that's what we've been doing anyway. Like, we taking lived experiences of people's lives into litigation and things like that. That's really how we have been doing. So what is Africanness versus Eurocentricness in this context? And how do you differentiate it from the problematic terminologies that we've been hearing from the other field?
These are very, very important issues, and I think that's why we came for this Baraza, to dig deeper in those issues.
I have been thinking pensively about classifying our approach. Whether we begin our journey from Europe or America, we must walk the journey. And when I went for women's law at the University of Zimbabwe, my Chief Justice, in granting me permission, asked me, "Why do you want to study women's law? Are you a woman?" Another time, he asked me the same question when I was going to, I think it was Ghana. We had a conference on safe abortion. It was called Keeping the Promise. Why are you going for safe abortion? Are you a woman? And I said, well, the men make the women pregnant. I want to understand it better. But it is time that we, the legal minds, question and problematize the law. Just like our political ancestors questioned the political times before independence, and we got political independence. They realized later political independence is not enough. Economic independence should come on. And now I'm asking, what have we done as legal minds? Are we still colonized or are we independent? Have we fought for our independence? No. I think it requires judicial activism to question the law that we inherited, whether it is applicable to Africa, applicable to minute communities, applicable to so many other classes, without stereotyping. That's what Mulumba is saying. And it is up to us. Where do we begin from is the big question. Because many of us are timid. I want to thank Professor Julie Stewart. She taught us to disregard precedent. And we said, what? The law is based on precedent. Said, no. The way the Europeans, for example, interpreted African customary law is not African customary law. So question it, problematize it, and give your own opinion. When a high court in Uganda gives an opinion, some people ask, are there precedents? I remember talking about questioning provocation and saying that we shouldn't be talking about provocation. The Europeans talk about it. Let's talk about accumulated anger. I said, are you bringing a new defense? I said, Lord Denning was a judge of the High Court in England. I'm a judge of the High Court in Uganda. Why don't you take my precedent? Questioned, reason about it. But there are so many progressive provisions in the modern constitutions we are making, or the amended constitutions. In all the African countries where we have amended the constitutions we got at independence, we have brought in an article similar to 274 of Uganda, that the coming into force of this constitution shall not affect the existing law, but the existing law shall be construed with modifications, qualifications, adaptations to bring it into conformity with the modern times. And that's what unties our hands. When we say our hands are tied by the law, no. That provision alone allows a lot of judicial activism. Those who are going to the calling on the bench, those who are coming to the calling at the bar, because it is a strong bar, which makes a strong bench, come with judicial activism and argue it. But that's not the case. When I get there, I'll tell you my stories about Uganda, where my own colleagues say, you are being too much of an activist. Do you have those powers to interpret the Constitution? I said, no, this is not a constitutional question. Every day we are applying and interpreting the Constitution. If you are talking about theft, what is it? Theft, the right to property. So we can construe our existing law with the modification, with the qualification, with the adaptation. What's the role of the CSOs, the academia? To do this research, to gather the data, update it. Why do we quote cases of 1869 when we can quote cases of 2023? Let us update ourselves and forget about being Eurocentric or Afrocentric or what. But can't we coin our own? And they say in 2023, Ahaki began the program, and out of it, this is what has come out. Can't you own it? Can't I own it? Can't we own it? If others did it, why don't we did it?
Thank you so much. We'll briefly hear from Professor Ben. I don't know if we are still well on time.
Yeah, thank you. I took long there. Now I'll be very brief. You say Manjongo. That's how you pronounce it? Eh? Manjonjo. Manjonjo asked, really, that why should we move away from reproductive choice, or even reproductive rights, including abortion rights? I don't think that's what we are saying. When we use the word beyond does not mean moving away. Beyond means that we are recognizing the existing, but we are adding. In other words, abortion rights are necessary, including access to safe and legal abortion. But we must interrogate other aspects of reproductive choice, including the structural and systemic constraints to realization of those reproductive rights. That's what it's about. It doesn't mean abandoning. Then secondly, I would encourage all of us to go back to our old book, which we saw in the undergraduate studies, John Rawls, The Theory of Justice. When general comment number 14, under obligation to fulfill, talks about facilitating and providing healthcare goods and services to those who by their own means are unable to provide for themselves. It is what, during our undergraduate studies, John Rawls used to call redistributive justice to ensure that you lessen these inequalities. So even if we talk about liberalized abortion regimes, how can we enable those women who are unable by their own means, either out of social challenges or income challenges, to access those? Secondly, I hope that is which I'll bring out, okay? So it's beyond means additional. We are moving beyond just a narrow focus on reproductive rights. Then again, I want to clarify this. Self-determination, you see, when we talk about bodily autonomy and the question of reproductive choice, like the Choice of Termination of Pregnancy Act of South Africa and the Ethiopian abortion law and the Mozambican abortion law, when they talk about access to safe abortion on demand in the first trimester, they are talking about the right to self-determination, a woman's right to choose. And as scholars, we disagree in the literature. My direction is that abortion should remain criminalized, but allowed under certain circumstances. Others will say it should be a free what? Choice. Academics, that is how our garden looks like. We live to disagree as we move on. And we respect each other. After that, we have tea or a drink for that matter. Okay? Finally, this issue of harmonization of Afrocentrism and Eurocentrism. I have argued elsewhere in some work that we cannot look at these two in separate compartments. In my view, each of these, whether Afrocentrism or Eurocentrism, has positive and negative attributes. And these systems can learn from each other. For example, the Universal Declaration of Human Rights, which you can say is the cornerstone of Eurocentric view of human rights, is a very progressive document in many other aspects. And the Universal Declaration of Human Rights draws from even principles or norms which are in the Bible and the Quran. When you look at what Jesus preached, when you look at the Prophet Muhammad, peace be upon him, the emphasis on humanity, the emphasis on good heart and good being and etc. These issues, if you decide to liberate your mind by just saying, I'm not going to demonize all religions, no. Okay? open up your mind and be open. Be open in all these things. Finally, let us recognize one important concept in human rights: diversity. A woman who does not want to abort has that right. Let us give him the requirement, the information about abortion. Let's tell her through the principle of informed consent in a genuine and candid fashion about the positives of abortion, the likely risks and harm, etc. To me, that is extremely important because informed consent is a major principle of human rights. Thank you.
Thank you so much, Professor. Since we have another plenary, I would request that we can make our comments. I will have a comment from Zimbabwe, Nigeria, Malawi, Kenneth, Uganda. Others, you will share your comments during the plenary we have, which starts at 4. You raise your comments or your questions, but they will be addressed in the plenary, which we'll be having at 4. So allow me to only have those because I'll be violating rights of other people. I think the right to food and health as well, because lunchtime has approached. So I will have Zimbabwe, Malawi, Nigeria, Uganda. I'll have Kenneth. I also say neither Uganda, but we'll handle you first during another plenary at 4. Thank you. Let me start.
Thank you very much. I think I have a couple of comments and then a question. I think these are some of the things I feel we may need to address maybe in the coming sessions or hopefully next presenters will address. The first is around the criminality of around SRHR. I think within it being couched in our penal codes and how that relates to the current conversation around reproductive justice. And I think for those who have time, I just want to draw your attention to a case we had in Zimbabwe. Unfortunately, we dealt with it when we were taught about it, around the issues of separation of trials during criminal proceedings. But it's a case of infanticide where the person who was assisting was charged with murder. And this one confessed and they were tried together and the co-accused testified. There were a lot of procedural issues that went wrong, but she sat on death row because she was convicted of murder, because she was assisting someone who was having a late termination. So these are the criminal sanctions can really be a lot, and we really need to delve into issues around the criminality and how then do we respond to prosecutions. And then I like that he spoke about Professor Ben spoke about issues of using constitutional rights, and I've often seen in many of cases that have been taken to court that they really focused on individual, of the rights of, not rights, but what happened to that individual. And in the end, the judgment you get only serves that individual and not the general population. So just getting more into the constitutional cases so that we don't then have to get every woman go before the courts for her to also enforce her rights. But even as we are doing our strategic litigation, it's broad enough to include every woman. And then the other issue really was around strategic litigation because the Mapinguro case was referred to. And I think one of the things we were discussing last week in Zimbabwe was in 2012, the judge said our Section 5 of the Termination of Pregnancy Act was vague in that it didn't really, it spoke about the authority, but it never defined who the authority is, and that there was a need to amend our Termination of Pregnancy Act. But 11 years now, and nothing has been done by the government. So my question is around accountability for implementation of judgments. How do we then ensure that there is implementation of these judgments as we are doing strategic litigation? What sort of mechanism can we then have in terms of accountability? Is just getting a court judgment for the sake of judgment, but how does it then transform the lives of women? And then just to add to Professor Ben, some of the things we've been encountering around migration status of women and how that has impacted their rights, their reproductive rights, especially if you're looking at Zimbabwean women, illegal immigrants in South Africa and how their status has impacted them, as well as how, in some instances, contraception is made part of antiretroviral therapy, that if you're on ART, you have to prove that you're also on contraception. Thank you.
Thank you. Malawi?
Thank you so much. So thank you to all the presenters and also the comments which we're getting from them. One thing that this made me think is just one word, which I've been reflecting over the past few weeks because of several events, including also when I read the determination of the Committee on the Rights of the Child on the Peruvian case of that girl who was raped and could not get an abortion. So that one word is stigma. How do we theorize stigma in this Afrocentric approach? You know, because stigma is that cloud which just, when it hangs over these issues which you are talking about, it just makes them difficult to talk about them. Right? So even when we attach negativity to abortion, we don't want to talk about it. And even when doctors provide termination to pregnancy, they have done the right thing according to the law, but when you ask them about it, they don't want to talk about it. It's stigma. Stigma. How do we deal with this stigma? Even the court, when the High Court was making that judgment, it was aware that there are certain issues that, I mean the Malawian judgment, there are certain issues that it did not feel comfortably to talk about. That's why I said, I don't want to open a can of worms. No? But it's the can of worms that we need to open in order to talk about these issues. How do we talk about about these issues so comfortably that we shouldn't fear when I am asked the question, oh no, I'm a Catholic or this, so why can't I just talk about comfortable about sexuality and adolescence? So yes, this is what we need to talk about. Stigma. How do we theorize it and make our approach Afrocentric? Thank you.
I think the cans are going to be opened.
Thank you so much. Yes, permit me to be on my feet to express this concern. I would like to start by joining my other colleagues to commend the two presenters for the incisive presentations we have had from them. Honestly, I think it has been so educative. Yes, my concern has always been this. Looking through the issues before us, we'll see that the centerpiece of these issues are two. One, freedom of choice. Then two, bodily autonomy. I mean, these two things are the centerpiece of the whole of our discussion here. And if we agree, then my concern will be that will it not amount to going in a circle if we say allow freedom, allow bodily autonomy and freedom of choice to a people whose values, for example, is have a very large family, to a people whose, and when I say this, before you disagree with me, take your mind off urbanized Africans. Take your mind to Africans in the hinterlands, Africans in the villages, which is where majority of us are as we speak. And so these are Africans that when given that choice, given that freedom, make your choice the way you want to make it. When given that freedom, you have bodily autonomy to determine whatever you want to happen to your body. What he or she will go for is, I want to have as many number of children as possible. I want to have a family as large as anybody can imagine. Now, if that is the choice that is likely to be made, then, and we do agree that at the centerpiece of reproductive justice is economic emancipation. Now, will this choice by a typical African who lives in the village, who is in the hinterlands, who probably does not have all the information that we in the cities have, then will it not amount to going in the same circle? Will it not go or in the way of the argument of some people that we cannot allow these people to make that unfettered freedom, make that choice for them, make that decision for them? I want the prof especially to respond to this because I know he has researched well in this area. Thank you so much.
Thank you. Professor is here for the entire conference.
Yes,
So he'll answer the questions in the subsequent conversations. Mr. Sevavi.
Well, I'm having a challenge to speak last, but I want to appreciate the keynote speakers, that is the Professor and Dr. Moses Mulumba, for the wonderful presentations. The approaches emphasized that we now agree to and subscribe to the Eurocentric and Afrocentric approaches. Of course, mutatis mutandis, that is with the necessary modifications. Professor said they have both negative and positive attributes. And Doctor has urged us to pick out the positive narratives out of the approaches. Those we truly appreciate. And I want to allude to the comment by Justice Cheborion about the awareness levels that are rising, to the extent that the gap, the information gap, the levels of awareness need to be enhanced for us to have a proper movement or a progressive development towards these rights. I'm shy to talk about petition 10, but Professor Ben alluded to it in his presentation. One of the key issues that came out when that petition came up before the Constitutional Court, we the lawyers were trading on one way, we were advancing our case, but also guarding against being misunderstood by the panel because of the subject matter of the petition, which is the abortion or termination of pregnancy. Whereas we're arguing that the omission of the state to enact the law that provides or that regulates the termination of pregnancy is unconstitutional, there was a school of thought that the petitioners seek to promote abortion, which was not the case. To the extent one panelist remarked that, do you want courts to be looked at as those promoting abortion? And it was quite hard. So we had to emphasize and put a disclaimer or an opening statement in our submissions that the petitioners don't seek to promote abortion, but rather seek to challenge the omission of the state to enact the law that regulates the termination of pregnancy. But by and large, all these allude to the awareness, and I want to believe and strongly believe that at the end of this session or at the end of this baraza, we'll have enhanced our levels of appreciation of these issues. Thank you.
Thank you so much. I think we should have a round of applause for our panelists or speakers, all the participants, whoever has raised a comment, those that are thinking about comments or questions, we should also clap for them. Those that are attending virtually, we thank you so much for following the deliberations. And I think we deserve a lunch. But before we go for lunch, I have a kind request that we take a group photo here. We'll return at 2:30 for our next session. Thank you. I think for the facilitator, should also, or the MC, as we climb up for the group photo. Yeah. Thank you. I don't know who is going to sit on the chairs. I can't determine that. And there are few. But I think Dorothy is good at organizing us for photos, so she'll advise who will sit on the chair. They will label you to have. We are going for lunch. We are going to exercise immediately after lunch. Yeah. I was advised that we'll have the justices sit on the chairs, and then for us we'll stand. Yeah. Harmonization. Can we go for the photo? Our lunch is getting cold. Yeah. The photo is for everyone. Good afternoon to all of us. I hope we enjoyed the lunch. I know Professor Ben was preparing for the Energizer, the 15. Is it 15 or 50? Oh, 50. So we'll give him time to give us the 50. Can we have the 50? So much, Professor, for that wonderful health exercise. We need to embrace exercise in our life. It's part of the a right direction for us, especially the people who are in this kind of work. We should lead by example to always accommodate those kinds of exercises in our agenda. But thank you so much for reminding us of physical activity in our life. We had some pertinent issues that came up, which I think it's very important to address before we proceed. We had a burning comment from Betty. She reminded me of a lunch that I had an issue, but you stopped me. I had to apologize and say it was time, not me who. But also, there was a question of reproductive choice, reproductive justice, Afrocentrism, Eurocentrism, which I think we need to get some clarity. I'll request Nimrod to shed light on that issue after we hear from Betty. So Betty, do you want to come here or you want to stay there? Okay.
Thank you so much, Mr. Nsereko. Welcome back from lunch. I would like to appreciate the previous speakers, but also to highlight briefly on what Professor Ben said. When we look at issues of reproductive choice and reproductive justice, let us focus so much, or let us not leave out issues of intersectionality and inclusiveness in terms of looking at the different categories of groups we work with, in terms of the minority groups like the female sex workers, women who use drugs, the elderly, women, disability, people. Just 2 days ago, I was talking to my mother. We had a conversation. I think I was 9 years old. And one man very early in the morning came at 6. And the conversation I had is that woman is, like, the wife had gotten pregnant at 61 years, and he was so confused. So these categories of people have unique sexual reproductive health issues that we don't usually address or think about in terms of their uniqueness. So the thing that Professor Ben highlighted in terms of intersectionality and uniqueness, even when these cases come to court, we need to focus on how unique is this particular case. If it's a person with disability presented to you, if it's a person who falls within the key populations, they have unique issues that we shouldn't avoid, the thing of leaving no one behind. So because it's a baraza, I wanted to also highlight this in terms of, yes, we shall be presented with such issues, and the issue of inclusiveness, the uniqueness of something is also key. Thank you.
Thank you so much, Ibra. Good afternoon once again. All protocol observed. I wasn't scheduled to speak until tomorrow. Even then, I was scheduled to speak as a panel moderator, but I was asked to clarify on a question that arose in the morning, and I think most of the questions were coming from this side. So, pardon? The question on Afrocentrism, I think, came up quite a bit, but also the question of, I think it was Martin who raised this, the question of whether we are seeking to reinvent the wheel with the concept of reproductive justice. So I would just like to maybe touch a little bit on those two issues. Professor Tunomugisha covered reproductive justice ably, so I will not really go into that, but I would just like maybe to discuss what our conceptualization or what we had in mind when we spoke about Afrocentrism. So the first thing I'll like to highlight or point out is that when we speak of Afrocentrism, we are not speaking of a return to an idealized fiction of Africa. We're not speaking of a return to an Africa where patriarchy is dominant, an Africa where wars are rampant, an Africa where pillage is, looting and pillage are rampant. No. When we're talking about Afrocentrism, we're thinking it is a new paradigm with Africa at the center. With Africa at the center of thought, of thinking, practice, and when it comes to CSOs like ours, like the ones we're from, or even the just handout, implementation. And Justice Batema has moved out, but he raised a very, very important point in the morning when he asked, why do we constantly rely on foreign precedent? It's a question that I've asked before also. You will never, ever, ever see the US Supreme Court relying on an African decision. Why do we constantly pick decisions from there to solve matters that arise from here? That's the Afrocentrism that we're talking about. So when a court is faced with an issue, let us not quickly reach for the crutches of a Eurocentric or an Anglo-American judgment as a solution. So what we're talking about is an Africa at the center, its people at the center. When it comes to reproductive justice issues, it's women and girls at the center. And it was a very good decision from Kenya. I think, Martin, you were involved in this FIDA versus the GMM petition, in which the judges highlighted the fact that it is usually women and girls from the lower echelons, from the lower socioeconomic strata, who face the brunt of unsafe abortions. So we are not saying that Africa can do it all on its own. No. There are concepts that we can borrow from other cultures, but those cross-cultural exchanges have to be equal. It cannot be one-way traffic as it is right now, right? So at AHAKI, our Afrocentrism works this way. I think Dr. Mlomba talked about this in the morning. The first thing that we would like to highlight is that there are positive African narratives from the continent that we can use, that we can leverage, okay, to push this agenda of sexual and reproductive health work, of reproductive justice work. And the decisions that have been mentioned repeatedly from the morning session are a good point to start. So the positive narratives. The negative narratives, we drop them. When it comes to, I think you mentioned patriarchy in the morning. No one is advocating for a return of that sort of society, okay? But then we also want to work with African institutions, particularly those at the supranational level. So the African Union, again, Martin, you bear witness here. For the first time, the African Committee of Experts on the Rights and Welfare of the Child, which unfortunately many people do not know that can also be an avenue for litigating some of these things, issued a judgment against Tanzania for its expulsion of pregnant girls from school. But we also have the African Commission on Human and People's Rights. We have the African Court on Human and People's Rights, which can be very good avenues for adjudicating these things, which can be very good avenues for adjudicating some of these disputes. And we need to utilize them. Because when it comes to, for instance, the African Commission, the lawyers who have actually litigated, I hope I'm right, the jurisprudence of the African Commission is not that strong when it comes to sexual and reproductive health and rights. ECOWAS has some good decisions, but at that level, at the level of the African Commission, we do not see that. And at AHAKI, what we're advocating for is maybe before rushing to CEDAW, before rushing to even the UN Committee on the Rights and Welfare of the Child, let's utilize the avenues that we have here, that were made for us, that we made ourselves, because it also deals with that legitimacy deficit. If you go to CEDAW, if you go to a UN body, and you bring it back to a national government, you can easily be accused of cultural imperialism, right? So it helps deal with issues of legitimacy. But we also want to work with African civil society organizations at Afya na Haki. And that's why the theme of the Baraza is a regional reproductive justice litigation Baraza, or agenda, that we can have, we can front these issues at a regional level and create a jurisprudence from which we can borrow. So that if Roe v. Wade is overturned in America, for whatever reason, we don't have to worry here, because we have good decisions from Kenya, we have good decisions from South Africa. We have a regional agenda that we can draw from without necessarily worrying about what is going on elsewhere. Then the fourth point I would like to highlight is the issue of harnessing the power of African individuals. And this is something that has been mentioned repeatedly from the morning session. The justices, the judges, the lawyers, but not forgetting the litigants themselves, that we need to harness the power and we need to leverage the power that we can draw from individuals, from activists, from scholars, so that we can all come together, right, and push this agenda forward. I would just like to maybe to end. So the discussion on Eurocentrism, Afrocentrism, it's a discussion that can go on and on and on forever. But at AHAKI, we decided Afrocentrism is the way to go. We are not saying discard everything Eurocentric, not at all. We are saying there can be positives. After all, cultures do enrich one another, but we cannot continue having that cross-cultural exchange be one-way traffic, where we are constantly lectured to, we are constantly told that, you know, we have to do this, we have to do that. Even with CSOs, our implementation agendas, we have to make sure that we shape them ourselves. I know, of course, issues of financing always arise. Those, you know, he who pays the piper determines the tune or something like that. So I would just like to end at that point. I know we'll have opportunities for further interaction on these issues. Thank you so much, Ibra, for the very short notice.
Thank you so much, Nimrod. Sorry for ambushing you, but I thought it is important to shed more light. But I think we'll have more conversations and more spaces for conversations on these pertinent issues. I know already there are other issues that are emerging from this, but allow me to invite my colleague, Lenny Sharon Pamela, to lead us in the next sessions. Thank you.
Good afternoon, ladies and gentlemen. I will also stand on the already established protocol, so I will not be repeating what has already been said. So as Afya na Haki, we believe in utility of research. Research should be able to be palatable and understood across the board. And arts are one of the ways in which we communicate research, but also relate to different groups of people. So in that spirit, the next item that we will be showcasing right now is a poem by Afya na Haki, where we collaborated with 2 young people, and the poem articulates certain aspects of reproductive justice that have already been discussed here and also are reflected in some of our work if you check our website. So I will invite Drake to please play the video for us. Thank you.
A long time ago, before you and I were born, our forefathers and mothers had full custody of a priceless gift.
A gift that gave ceaselessly, a lifeline that linked generations endlessly, a gem that was shamelessly stepped on.
Our kurambire, our forefathers and mothers, they understood. They understood the value and context of this, our sexuality complex. To them, it was more than just intercourse.
It was a source and a resource of continuity and multiplication. One without a replica, of course, a treasure of invaluable pleasure, devalued by foreign values. To our forefathers and mothers, Eriba Jajafe, sexuality was a place of pride and purity that shaped the community, a place where identity made love to responsibility and gave birth to hope.
A hope that now hangs on the ropes of the foreign man on top. Kwa mababu wetu, to our forefathers and mothers, reproductive justice was the key.
The spiritual key that unlocked possibilities for the society until it got locked up by obukila, slavery.
To our forefathers and mothers, sexuality was poetry, a metaphor of succession,
a representation of the interconnecting political, social, and economic fabrics. Sexuality existed above the confines of the white man's metrics.
Our forefathers and mothers,
Okoko, listened to the whispers of equity and agency, the whispers of reproductive justice and mediation, the whispers that were wisely woven into socialization until they were muffled by the noise of colonization, a distortion that still rattles the African civilization. To our forefathers and mothers, the fabric of being was like water, freely following the flow of function with a clear introspection of home. A home where stigma had no seat at the table, a community where masculinity and femininity danced in the kitchen of necessity and in the hunting ground for survival.
Their purity of mind was unrivaled. They were the Venda of South Africa,
the Nandi of Kenya,
the Kuria of Tanzania,
the Bara of Madagascar,
until they tasted the tears of Okonko, and things fell apart as gushing white waters formed a river between them and their identity,
between us and our identity. Now look at us. See, a society drowning in a sea of delusion, lungs submerged by waters of confusion, drowning. Our sexuality is drowning because we have lost touch of our ancestral grounding. Look at us. See a sea of confusion, a sea of delusion, of floating spirits in bodies we no longer own, chanting creeds of autonomy, recycling and reusing narratives that continue to reduce our own ideologies. Look at us. See, lava, leva, bona, tazama.
Look at gender. Before that, throw away your foreign lenses.
There's a lot to unlearn before we come to our senses. See, or rather, unsee the notion that there is sin in your sexuality. Abandon that narrative because it is not our own.
Let us weave our own paths of reproductive justice, with threads of gender, race, and class intertwining, with diversities converging at the threshold of an African identity.
Let us mold our own methods of mediation, form our own fields of assimilation, and put a stop to this disease that is discrimination.
Let us rise up with voices united and strong in the fight for justice where all belong. For the path to liberation is not singular. It's as complex and diverse as our ancestral root system.
Let us follow the teachings of our roots. Roots like Mulondo that instruct the male anatomy. Forget Victorias and remember the secrets of the acacia tree that instructs us to honor our bodies.
Let us reclaim our reproductive justice, an Afrocentric approach of breaking chains, celebrating the resistance that flows in our veins.
Together, we advocate, educate, and inspire, building communities that stand strong and aspire. In the litigation of justice, we find our voice, reimagining a future where Africa can rejoice.
That's a conversation we can have after, but yes. Okay. Professor, thank you so much for that guidance. We shall continue the conversation. So next on the agenda is a panel discussion. And the theme of this panel is reinvigorating Afrocentric jurisprudence. This panel will be moderated by Jessica Oga. I'll give you a brief bio about Jessica. Jessica is a PhD fellow at Afya na Haki and is also an associate at HELC and a doctoral candidate at Babok University, where she's researching on protecting the sexual and reproductive health and rights of internally displaced women in Nigeria. She has supported various national and subnational initiatives in Nigeria. She holds a first-class degree in law from Benson Idahosa University, an executive master's on the law of non-international armed conflicts from the Geneva Academy, a Master of Laws degree from Babok University. Her interests include sexual violence, non-state armed groups, sexual and reproductive justice, health, and gender equality. Finally, her determination to succeed comes from the belief that there are far, far better things ahead than any we leave behind. And she quotes C.S. Lewis. Jessica, you're very welcome to take on the next session. Please invite Jessica.
I am overwhelmed. Thank you so much. Good afternoon, honorable justices and distinguished audience. I would like to stand on existing protocol. Today, I'll be moderating a discussion on reinvigorating Afrocentric jurisprudence. Before I call on our expert panelists, I would like to give a brief introduction on the topic Afrocentric jurisprudence. Afrocentric jurisprudence is an approach to law and legal systems in Africa that seeks to prioritize African perspectives, values, and cultural norms, It challenges the dominance of Eurocentric legal systems that were imposed during colonial rule and aims to develop a legal framework that is more in tune with the needs and aspirations of African societies. It's important to note that Afrocentric jurisprudence has its roots in African history and pre-colonial legal system. The sexual and reproductive health and right landscape in Africa is marked by significant issues such as high maternal mortality deaths, limited access to contraceptives and abortion services, among several others, which underscores the need for a robust legal framework and judicial intervention. So it is no surprise that courts have taken a central role in the determination, articulation, and adjudication of sexual and reproductive health and rights in Africa. Today, we'll be discussing on the numerous ways African legal systems can contribute to the advancement of reproductive justice in Africa. So our panelists will be speaking as experts on reinvigorating African jurisprudence. Please join me in welcoming our first panelist, who is a magistrate in Uganda and a law lecturer at Islamic University in Uganda. He is very passionate about human rights, and he envisions a world free from oppression, violence, and exploitation. He's no other person than His Worship Abubakar Matanda. Thank you so much. We're excited to have you. Our second panelist is, yes, is a judge at the High Court. He's passionate about establishing new trends in the delivery of justice, jurisprudence of gender equality, and redefining concepts and legal principles. He is fondly called Sister Batema as a result of his pursuit for gender equality. He's the author of several books that promotes gender equality and women's access to justice. Please join me in welcoming no other person but Your Lordship, Honorable Justice David Batema. Thank you so much for coming, Your Lordship. Our third panelist is a judge at the High Court of Malawi. Prior to his appointment as a justice, he served as the president of the Malawi Law Society. He was popularly known as a human rights lawyer and is a strong advocate on access to justice. I am speaking about no other person than Your Lordship, Honorable Justice Mandala Mambulaza. Thank you so much for coming. Thank you so much. We're grateful. I am particularly excited about our fourth panelist, and you'll soon find out why. Our fourth panelist is a judge, is a High Court judge in Uganda. She was awarded the Prosecutor of the Year award in recognition of her role in the prosecution of the 2010 Kampala bombing suspects. Please join me in giving a rousing welcome to Your Lordship, Honorable Justice Susan Okalani. Thank you so much. Our last, but definitely not the least panelist, is a judge at the High Court, at the Court of Appeal in Uganda. My apologies. He's also a member of the East African Court of Justice and is known for leading the struggle for people's rights and freedom. I am speaking about no other person but Your Lordship, Honorable Justice Cheborion Banshaki. So before we delve into the panel session, Honorable Justice Cheborion would be giving us his paper on African jurisprudence. Thank you so much.
I really don't have a paper to present. Looks like Afia Haki has a lot of ambushes. First of all, they asked us that we are going to answer questions. We are not used to being asked questions. We are the ones who ask questions and expect answers. But that said, I had just thought that maybe we could get some statistics of the subject we are talking about. And I looked at some statistics and saw that Africa's sexual and reproductive health and rights trajectory is one of a resolution that has deferred for a long time. 94% of African women live in countries with restrictions on sexual and reproductive rights. And it is no wonder that 8.3 million of them terminate pregnancies in unsafe conditions. 209,000 women in Africa die annually from pregnancy and childbirth-related causes. So you can see these statistics. These are actual. This is what is happening. And that is why I thought I should bring this to your attention so that you can see the magnitude of the problem and find a way how this can be sorted out. And this calls for a shift in how we think, how we work, how we do our work individually. So that is what I thought I should bring forth. I don't have a long paper. I think we should go to the discussion. I believe these young panelists, for me, I'm in the league of professor. And we don't have a lot of, we do a lot of exercises. That's why we're a bit lean. But we look forward to a discussion in this area. I thank you.
Okay, so just go right into the panel session. So the first question that we have is borders on outdated colonial laws. So many courts addressing sexual and reproductive health and rights in Africa continue to be based on outdated colonial laws, specifically criminal legislations that fails to adequately reflect the changing and contemporary needs and aspirations of African societies. So the question, my lord, is, given the pressing need for modernization and alignment with contemporary societal values, how can the judiciary proactively contribute to the reform of outdated colonial laws related to sexual and reproductive health and rights in Africa, while ensuring that there is a balance between respecting cultural context and safeguarding individual liberties? So I think I would like to start with Honorable Justice Cheperian.
Thank you. Now, certainly my starting point is that I think each case should be treated on its own facts. There are colonial laws that are still relevant and helpful to our systems, to our judicial systems, to our jurisprudence. So we cannot make a blanket position that all colonial laws are educated and cannot be of any use. I think we should treat each on its own merits. But the judiciaries have a responsibility in interpretation of laws to ensure that in so doing, they ensure that there is protection of rights. That there is protection of rights, whichever law you are interpreting, And you weigh it against, in Uganda, for example, against our constitutional provisions. What does the Constitution say? Our Constitution is elaborate in protection of reproductive rights. Our Bill of Rights, I think, is very elaborate. Although we came later, we came first, we're not able to benefit from other jurisdictions in the region. Unlike Kenya, which looked at our Constitution and developed its Bill of Rights further, well, in my view, still ours is good enough. So we have a responsibility as judicial office to ensure that all laws, not only colonial laws, but all laws, including post-colonial laws, laws that were enacted after independence, conform to the Constitution. In so doing, we'll then be able to remove those laws, and most of them are pre-colonial laws. I mean, we are able to remove them through interpretation. You can also use enforcement. You look at laws and say this is unenforceable, and therefore, you don't give any orders that whatever is being sought is enforced. So you weigh the laws against the Constitution. You use enforcement. You use interpretation also, and declare them as unconstitutional and should be removed from statute books. I think in that way, you will be able then to bring up laws that we ourselves as the Ugandans or as citizens have come up with. And then you protect those laws that have been enacted after colonialism. But it shouldn't be that every law that is enacted after the colonialists left is good law. We've struck down so many of them for being in violation of the Constitution. That's my view in brief.
Thank you so much. Thank you so much. Honorable Justice Batema, do you have a dissenting opinion or you have a similar opinion?
No, when the Court of Appeal speaks, the High Court has to be very, very careful. I can only add. I may not agree in total, but I have to add. One, words are our tools of work as lawyers. There must be a careful purification of the language that we have to pick from the existing law and redefine particular words, particular terminologies, particular things. We were eating matoke, and I was warning my sister from Zimbabwe. We were not eating bananas. We were eating matoke. My banana in Zimbabwe is sweet banana. So when you say we are eating sweet banana, I think matoke loses the context. Similarly, in the olden laws, we have to revisit the laws. We have to revisit terminologies. Some laws have no definitions for particular things. I was reviewing the law of rape, and there was no definition of rape or consent in the whole penal code. So as we revisit the law, we begin with the language. If we are going to make it gender neutral, maybe the better. Are we talking about a chairman or a chairperson, a head teacher, a headmaster, or a headmistress? That one can redefine the law by way of definition. When it comes to application, this morning I quoted particularly Article 274, that the existing law is too much. It cannot be changed by Parliament overnight. So we continue to apply the new law and the old law. Now the question is, what should we follow? Haki is saying maybe Afrocentric. And I'm saying not necessarily, because what is our parliament composed of? I don't know about your parliaments in your countries, but I can literally say these are fishermen and vegetable growers. And nobody will feel ashamed, because our president said he's appointing fishmongers as prime ministers. So if the vegetable growers and fishmongers are going to make the law, what do you have as the academic, as the land people to do? Fine-tune that thinking of theirs into law which is acceptable at the international level. The Constitution is supreme, yes. How do we change certain things? By following international human rights standards. If Uganda is signatory to particular conventions, covenants, declarations, regional treaties, where is our stand? So that we move with the global movement and we don't think about Maibusoga, Maibuganda, we as the Bagisu. No. We should think internationally by following international human rights principles. But also we should constantly question our African origins, where we have come from. There are certain things we didn't know, and science has opened our eyes. Should we continue believing what our ancestors believed? I didn't have time, but I printed out one copy of my judgment about cultural rape in Karamoja. If you want a lady for a wife, the terminology said, make her a wife. So how do I make you my wife? I chase you, I throw you down, I eat the pie. I've made you my wife. So when the case comes of rape, they said, no, I didn't rape her. I only made her my wife. I paid the dowry. So in this judgment of Nakupoyet, it has a lot to inform us about the right to choose a spouse and the right to choose to have children. Because if you are going to chase and put me down, maybe I'm not a Karamajong. I'm from Zimbabwe. I'm from Kenya. Don't make me your wife that way. Should we continue living in the pre-colonial times? No. We must follow the international standards. Thank you.
Thank you so much. The second question, it's in light of the limitation, since we're not saying that every law that has been made pre-colonial times is wrong, but in light of the limitation posed by Eurocentric approaches to sexual and reproductive health and rights issues in Africa, the question is, how can the judiciary integrate and prioritize African-centered frameworks when interpreting and applying laws, while also ensuring that social and economic contexts are carefully considered to foster the development of contextually relevant solutions? My question is, let me reiterate, how can the judiciary effectively integrate and prioritize African-centered frameworks when interpreting and applying laws that are related to sexual and reproductive health and rights services? Justice Mandela.
Thank you very much. I think listening to the discussion since morning, it's clear that sexual reproductive health rights are fairly a new discipline of the law. And therefore, many of us may not be familiar with the terrain. And for me, it's therefore incumbent upon, those of you that are well versed in this area of the law to help the court as officers of the court, especially when you're drafting your pleadings. Help us, because as they say in computer science, garbage in, garbage out. The way you frame your pleadings, I think is important. The gentleman from Kenya, in the morning, he was saying they really took their time to help the court to get the result that they were looking for. I think, to me, that's one thing that I think we should, try to do, so that, we help the court. But also, listening to Professor Ben, the jurisprudence that he has given us, make it available to the courts. Show them what other courts are doing in the region, so that, through that, we can get the inspiration. But also, I would say that, again, as Professor Ben said, these are quite emotive issues. And as judicial officers, I think we come to the bench with excess baggage. But if we're going to execute the mandate that is bestowed upon us, I think it requires of us to be bold and realize and take seriously the judicial office that we take, that it requires of us to do our work without fear. We save all people, and be bold and take the risk and make decisions that will, to use the language of Godfrey, what was it? That will, when he was talking about stigma, that will open up a can of worms. Take the risk. That's what I would say. Thank you.
Thank you so much. Let's take the risk. His Worship Abubakar, please, any addition, not dissenting opinion.
Yes, thank you very much. I'm privileged to be appearing with my seniors. You need to know that in the judiciary, like in the army, we take hierarchy very seriously. So I'm a bit intimidated by the panel, and as you can note, I'm doing a lot of writing. But that's not to say I cannot share. And since I'm a magistrate, I would like to share a perspective that possibly also speaks more to the lower bench. Because, when you talk about public interest litigation, for example, strategic litigation, especially in Uganda, you find that the fora is mostly the High Court and the Constitutional Court. And guess how accessible these two are to the people. Like in Chibuku, where I serve, you can imagine how many people there have access to the Constitutional Court or even the High Court. And so the court that is accessible to them is the Magistrates' Court, which many lawyers will tell you, and even some judicial officers, has no jurisdiction to hear those matters. Now, to answer the question of what the judiciary can do, or what judicial officers can do, and I was asking myself, what can I do as a magistrate, for example? And I think one of the places to start is in the mode on how we run court. Our system, especially for a magistrate like myself, is adversarial. And so the court sits back, you come and ask, and you tell us whom your right to be enforced against. They also respond. And then I give a decision. Many times you find us saying the court cannot give you what you have not asked for. Now, that mode of operation is akin to the mode, the contestation you have been hearing about asserting rights and agency, and then looking at them in full context of social justice, or going beyond just the right. Why? You are asking this victim in Chibuku to make very good prayers and prepare the evidence in a way that makes sense. And sometimes the perpetrators, many times, are in a better position. They are likely to even have a lawyer. And so the burden. So what do I look at as a solution that we can do? I see that this kind of reproductive justice and indeed enforcement of all human rights requires that we descend to the arena as judicial officers. And that's when you see us issuing structural interdicts. Very soon, I think you see one structural interdict from a magistrate's court. Yeah, structural interdicts. But more than that, to also help cases. Because like in my court, there are very few lawyers. Mostly, I only have litigants. So I have to descend to the arena and be a lawyer for both sides. In a way, make the case this side and also make the case this side and then decide it. You know? So for instance, I was reviewing, now like in Uganda, we're even lucky. In 2019, our parliament passed the Human Rights Enforcement Act. That law, I don't know how many of us have read it, but the law has shocking provisions. For example, Section 5, enforcement of rights and freedoms by magistrates' courts. A magistrate court shall hear and determine applications relating to the enforcement of violation of human rights and freedoms guaranteed in Chapter 4 of the Constitution in any of the circumstances not referred to in subsection 1 of Section 4. Subsection 1 talks about, or reserves for the High Court, are those that involve non-derogable rights and freedoms, and then those in Article 45, which are extensions, and those restricted in the state of, during a state of emergency. Meaning for all the others, this law gives me jurisdiction to entertain matters involving enforcement. I do not know of any decision, and I've not seen any application in my court for this. That means we need to sensitize the public about this law, but also target us as judicial officers, because like you heard from the lady in the morning, human rights at university, at LDC, is an elective. And well, I'm using Uganda as a case study, but I know these realities apply to the other countries. So that means even just for this law, can we have some of these cases of these girls in magistrates' courts determined? And guess what Section 5.3 says? Actually, 2 says, the application under subsection 1 may be in any language, or orally, or in writing, or any other form that may be prescribed by regulations. And then 3 says, where it is oral in any other language, the magistrate shall reduce it into writing, into the language of court. This means this lady who has been battered can only walk into my court and start saying, I've been beaten. By who? By so and so. And I draft the petition. And then summon them, and they respond. But now if we sit back and wait for her to draft a notice of motion and do an affidavit and ensure it is commissioned, it will never happen. And for my sister from South Africa, that's what we are saying, that it's not enough to just say you have the right to choose. Choice presupposes that you have options. The option we are giving her here does not exist for her. She does not know it. She does not even have resources to cause it. But you tell her, if you're a girl or you're a woman and you have had this violation, walk to any magistrate's court and tell the court about your issue. But then I can tell you as a magistrate, you have to first cause some trainings on our side. You have to first cause some trainings on our side and some operational funds for paper and other things. Yes, but all I'm saying here is that for me, the wind I see is in agency. You can call it judicial activism, but there has to be an element of descending to the arena. And for us in Uganda, we are very lucky that the law has already even empowered us in many respects to descend to the arena and try to think just beyond what is on paper, what is required, and that's part of the colonial legacy. Possibly it was coming from a society that was used to writing, and you can easily understand. Some lawyers can't even differentiate a chamber summon and notice of motion. But where it came from, it made sense. They understood what a chamber means and what to be summoned to the chamber. But now here, we have to operate in that, and if the lawyers don't understand, how about the court users? Thank you.
Thank you so much, Your Worship. Thank you. One key feature of reproductive justice is that it goes beyond the deciding on whether the individual has a right over their reproductive lives. It encompasses a broad spectrum of social, economic, and cultural considerations. In the ROPA case, the courts noted this consideration when he noted the age of the victim, who was 13 and was studying in P5. He found that getting pregnant made her shameful among her schoolmates. He further held that the victim needed to continue her lessons in school, and bringing up a child would prevent her studies as well as her future life. So in light of this, my lord, my question is, how can Afrocentric jurisprudence further strike a balance between respecting cultural norms and values while upholding human rights principles that goes beyond just individual rights but encompasses social, economic, and cultural consideration, especially with regards to minor? My lord, Honorable Justice Susan.
Thank you. I am still waking up from my former self. Before I had many presentations today about Afrocentrism. But what I can say is essentially human rights standards internationally accommodate cultural rights, but only to the extent that they don't contravene human rights. And so where human cultures or cultural practices go against international standards, I don't think a court that I'm sitting in will recognize those rights, those cultural rights. The point I'm trying to make is that you have to balance between the standards, the international standards, the constitution, the laws, in as far as they don't abuse or they don't contravene the culture or even the law itself. We have the Evidence Act. You asked the question about colonial laws. Our Evidence Act was photocopied from India. It's, I think, a 1870-something piece of law that we implement. Many aspects of it are very good. Some aspects are not very detailed and don't talk about, for example, gender issues. They are not directly referred to. but we are still implementing many of those aspects. But if the law is, the legal framework contravenes those well-established international standards, the rights that are now well-recognized, reproductive rights, then I think that a court, if it is moved, that one has also been brought out clearly, that the court must be moved, can't strike down basing on our laws. Basing on international standards. And of course, our constitution is a miniature of the Declaration on Human Rights. So we have to also understand that many societies in the world, or in Africa, are actually patriarchal. And in the sense that it's a male-dominated society. And so many things that affect women were enacted and are perpetrated to maintain power relations. That is something that is causing a lot of confusion in my head with the messages that I had this morning. So as long as something is not perpetrating patriarchy and power relations that disfavor women, then I can uphold it. I can uphold it. FIDA Uganda has been working with a court, a patriarchal court system in Acholi to enforce women's rights, those who have failed to be, rights that have failed to be realized by the traditional normal courts, so that victims of sexual violence can present their cases in that traditional court. It has a 3-tier appellate system. We worked with them on a project for about 3 years, and at the end we noticed that they need to be empowered, they need to be sensitized. They had positive things like privacy in proceedings. So women freely discussed their reproductive infractions. So that was positive vis-a-vis our procedure, which is more open court and so on. So where the system, the traditional cultural system promotes women's rights and the rights of survivors, the court will enforce that, at least a court that I'm sitting in or presiding over. But basically for me, the rights, international standards must be upheld. Thank you.
Thank you so much, Gilad. Yes.
Just to add on that, African societies have varied cultures. There's a lot of diversity. So when you're talking about getting back to custom, you're talking about customs of hundreds of ethnic groups. I think the challenge comes in which one then would you want to lift up, which one would you want to take down? Maybe I think what we should be thinking about is respect for all these varied cultures and seeing how to encourage all of them to come on and be respected and promoted. And in my view, as my brother from Malawi said, I think the bigger part of the job lies with the lawyers, with the activists out there, coming to the court and presenting material. We encourage amicus curiae, coming as friends of the court or as interveners. I think we also do encourage them at the East African Court of Justice that you come in and bring all these views forward. Let us know about what is behind the legislation that we consider. We go back and maybe look at the debates in Parliament, look at writings on culture, have a look at Hansards where they are valuable, so that we can then use that as a basis of coming up with our own jurisprudence.
Thank you, my lord. Honorable Justice Batema.
Yes, may I add? When it comes to our African culture and then they inherited ordinances and laws from our colonialists. One must take a deliberate move to study the stereotyping in our laws. Why was this jurisdiction, for example, given to a politician and not a judicial officer? Like, you create a lacuna in the procedures, in the laws, and you say that one will be decided by the district commissioner. The district commissioner had to be a white man. So if one said is mentally disturbed and is being tried, say the judicial officer cannot sentence that one, but the district commissioner will, or the minister will. The file should be referred from the High Court to the minister. So unless we tackle stereotyping and know what attributes are given to particular genders in the colonial laws, we may fail to understand particular things relating to the laws. Many of the family laws were left unlegislated and were referred to as customary law. That the Africans handled their family matters, their marriage laws, their whatever. Now, if we don't question that, you may never intermarry. Because if you want to marry from West Nile and you're coming from Eastern Uganda, the customary law will be different. How do you present the bride price? Is it a bride price or a bride gift? If you are uncircumcised, will you be able to marry from Bugisu or not? If you are going to introduce, you are Muganda and you are going to introduce a Munyoro who was fighting the British, are you welcome or not? Then you are looked down upon. So when we are weighing what to take and what to leave, we should also pick out that stereotyping, so that as land people, when we are making our orders, rulings, judgments, we take the judgment or the courtroom as a classroom. Many times when I was introducing judicial activism in my judgments, I would write a sentence and say, before I take leave of this matter, and then people say, aha, now he's going to ramble, international human rights. Before I take leave of this matter, I introduce in the SIDO, I introduce the vow, I introduce whatever is required. Should we be limited to the facts? Maybe we shall never teach our people. As a magistrate, as a chief magistrate in Mbale, I was able to write judgments which some high court judges were saying, we wish you were a high court judge. We wish you were at the higher bench. So, my brother, take courage. Take courage. You write what you feel is correct. Time will tell. For us who think we are in a high court, we are very big people, time will tell how stupid we were not to follow your president. I would think so. Be brave enough. Lastly, I keep saying we are very powerful people. The bench is a very powerful institution. Apart from the politicians who have a daily forum to go on to microphones and shout, for us we shout once, but ours is nailing the last nail in the coffin. Let the politicians talk. Let the politicians debate. If you find that their debate is not okay, inform them in a judgment, a ruling. Give them directives. You can even give time limits. So I want this changed in 2-3 years. Report back to us. And then people wake up and say, oh, we are powerful only when we are in the chair. But when it goes to the judiciary, we are told where we belong. When it comes to reforming the law, it is you, the bar, and us, the bench, to reform the law. When we continue singing the song of the politicians, we may never get it right. When we continue singing the song of parliamentary language, for them they'll just say, what we're interested in is remaining in our chairs. What are you talking about? Marriage. We even hear it from our leaders. Say, we shall have money for scientists. But these courses like women's studies, studying women for 3 years, what do you gain out of that? Huh? So it is us to pull our ropes, put things together.
Thank you, my Lord. His worship.
Thank you very much. I want to make a comment on this issue of Afrocentric approaches. The entire conversation seems to be looking at the good that we can pick from our cultures. But for me, I look at it more as a call for us to be aware of the context. So that means then we shall be able to even see the bad. I'll give an example. I've handled cases of domestic violence, and there is very little jurisprudence, and which we, as a magistrate, I say now it's an opportunity to start growing it. In these domestic violence cases, many times after 1 or 2 hearings, the victim, usually the woman, will come and say, we have reconciled. The family sat, we have discussed, she has apologized, and the court will be full of the families. Actually, sometimes you see, you can see the parallels. There's the one family this side and the family another. Now, the Constitution and the Magistrate Courts Act enjoins me to promote reconciliation. But if I just look at it on the face of it and say, yes, they have reconciled, I'm enjoined to promote reconciliation, the case is closed, you're discharged, you go. There could be a problem. My approach may be different if I'm aware that possibly this reconciliation is forced. The families have sat, her family has told her, where are you going? You've put the man in prison, now the children. She has a swollen cheek, but she's saying they have reconciled. Is she the one saying it? Or are there patriarchal spirits speaking through her?
The man is in prison, so they have not met with the woman.
Yes.
How have they reconciled?
Yes. So there is social pressure on one hand, and even economic pressure. Maybe when she goes back and sits down, realizes because of what we already know, the historical and cultural things, she has no land to inherit, she has no property. Where is she going? Then she says, I think let me endure the pain. So now me, who is presiding over that matter, or who is prosecuting, or who is an actor in that context, if you are aware of that, that's when you can go beyond that. For example, there's one case where I decided, still looking at the Human Rights Act, I saw that it empowers me to execute guarantees of non-repetition. So I say you have reconciled, meaning you accept you did it. Okay, so the reconciliation is okay, but you're going to plead guilty. We go through the process and you execute a guarantee that you will not do it again. If you do it again, ABC will happen. Then they can go. Because previously I had a case where they left and 2 months later, still the woman came to court limping. It has happened again. So for me, the way I look at the call to the Afrocentric approach is to pick out the good, yes, but also to know the bad. Because if you're not aware, if you just, these laws, it's true that even those that are enacted now, leave alone the colonialists, even the laws being enacted today in our parliament, they are mostly copied and pasted from other contexts. So you find you have copied it from a society where sharing of matrimonial property is not an issue, or where contracting for the parties is not an issue. Now, when you bring it here, in applying it, if you're not awake to our context, you are likely to perpetrate and occasion an injustice. So for me, I look at it as a call to be aware beyond the text, the letter of the law, as he mentioned, such that we can give room to deal with some of those issues. Thank you.
Thank you so much. Thank you very much. My next question would be, given the historical injustice related to sexual and reproductive health and rights, such as forced sterilization, reproductive coercion, and the rest of them, how can we say that, to what extent can we say that colonial legacy has impacted current legal frameworks in SRHR in African countries? And what steps can be taken to decolonize this legal framework? Justice Mandela.
Okay. Just to link that to what His Lordship was saying about the language that we use in our judgments, or that are in our laws. I had a case of someone who was, for lack of a better word, I was to use gang raped. He was a male, and he went to a male section of the prison as well. So he was gang raped and was infected with HIV. And the issue was reported, but then, the question to us was, can we use the language of rape? Does our law recognize this as rape? You see, so it was difficult. So the language that is used was difficult for us to conceptualize a rape sort of case and seek a remedy in that context. And what is more interesting about this is that the HIV and AIDS policy used to say that we know that these practices happen in our prisons, and because of that, we shall be disputing condoms in prisons. Go to the prison and ask them. They say, no, we can't. We won't allow you. The policy may say that, but we won't allow disputing of condoms in prison. Why? We'll be aiding and abetting. It's criminalized. But these things are happening, and people are being infected. And then we just take an ostrich approach and just bury our heads in the sand as if nothing is happening. They go and infect our sisters, our aunties. Are we dealing with the problem? These are some of the questions that we need to ask ourselves. And again, on the issue of language, in Malawi, one of the judges has said that, as far as I'm concerned, the concept of corroboration in sexual offenses, that we should not trust what a woman says. To me, it's unconstitutional. And so in our court, you actually know that you're not required to plead those kind of issues. So, and she has been courageous and come out and pronounced it in a judgment, although there's no agreement because it's a high court decision. Another judge has disagreed with her, but at least start the conversation. Let's see where we go. The Supreme Court may come in later on to correct us or whatever, but at least let's start the conversation and let's do what we can do. So in summary, I think to me the impact of many of the laws are so clear. We see them every day. But in terms of how we go about this, I think it will depend on the context of the country. It's so clear, South Africa, Kenya, our colleagues seem to be progressive. You can raise these issues in courts. Some countries are a little bit conservative. You can't bring it in court. Maybe in others, maybe you can raise it. You can take the you can amend or whatever the laws through Parliament. So for me, I think it will depend on the country and how far they have moved. For others, litigation may be the way to go. For others, maybe review through law reform programs or parliament may be the way to go. So I think it will depend on the context. But also, to me, I think like we need to take some of these issues beyond our domestic courts and see what the regional courts are going to say. I won't give the obvious example of Uganda, but I've been wondering to say, if someone was to challenge, for instance, the law on the LGBTI in Uganda, would you say that you can exhaust domestic remedy in Uganda, or we can take it for granted that I think for Uganda there's no, it's difficult to exhaust domestic remedy, and therefore let's go to the African Human Rights Code and what have you. So the point is, I think let's try to litigate also at the regional courts and see what they'll say where we can't make progress at a domestic setting.
Thank you so much, my Lord. Justice Bashaki.
Just for information, we already have 3 petitions on that matter pending in the Constitutional Court, so they will be heard, and I'm sure we'll come up with the positions on that. But my own take is that the issue of economic empowerment is also crucial. Because when you look at petition number 16, one of the ladies who was pregnant, who went to a health facility, was asked for money. The doctor on duty was not around. I think the doctor on duty was out there, and the nurses who were at the health center, either working with the instructions of the doctor or on their own, asked the pregnant lady who was due to deliver for money and said, "How much do you have?" And the lady had very little money, which they said, no, this can't work. So they didn't call the doctor. And because they didn't call the doctor, the lady bled to death. So the unborn child died, she also died. And in my decision in that matter, I said she had died because of corruption, which is a bigger problem actually now. So we have all these issues which we must address. And these are real issues. You may talk about all these factors, but if you don't address the basics, when you go to a health facility and you don't have 5,000 shillings, Uganda money, which is $1 and some cents, and that is what these people want before they can then give you treatment. They can then put on gloves, give you gloves to, and when you don't have it, they don't care. So it's issue of ethics. It's issue of ethics of our people. They don't appreciate that they get a salary, they have accepted to this work, and they don't have to be difficult to people whom they know don't actually have this money. Because nobody wants to die if you have money. Now, this is a bigger problem, which we must talk about and be able also to address in our discussions.
Thank you so much. Thank you so much, my Lord. The next question is, what role, it's similar to the question before, what role does Afrocentric jurisprudence play in addressing historical injustice related to SRHR, such as sexual violence, reproductive coercion, and even harmful traditional practices? Justice Susan.
Thank you very much. In addition to the answers that my colleagues have just given, I will probably emphasize that we are waiting for another case from whoever it may concern, including Ahaki, because we can't move ourselves. But we are frustrated on the other side. I'll speak for myself. Because of my practice of 17 years as a prosecutor and dealing with victims of sexual violence and other traditional harmful practices. Those two particularly among of the things that you have listed as requiring redress. And the problem is poor investigations. Just like we have a poor health response to victims or survivors. Forgive me for using the word victims. It comes from my long history of prosecution. It is not meant to belittle the survivors at all. But sometimes I forget to use the word survivor. But that is it. They don't get, or anybody who requires health services in this country is in big trouble. That is the truth. And recently, because I have family members who are in the medical profession, including my own mother, who has just retired, she's like, they were told not to say it, that there are no drugs, there have been no drugs supplied to health centers for the last 6 months. Medical officers are expected to look at the patient, make their examination by looking, diagnosis, by looking and hearing the history. There are no resources for diagnostic services, and then send them with the papers to go and get medication. So that is the status. Now, same to the police. They don't have police form 3A specifically. There are many forms, but let me talk about 3A. And they don't have transport, they don't have many things. And when you say this in the presence of police officers, they will deny it. They denied on Thursday, they denied it to a group of over 200 women who were saying they are charged for photocopying, they are charged for the next step, they are charged for transport, they are charged for arrest. And that is the system. These are systemic problems that cannot be addressed in the small cases that the victims or the survivors are suffering. And so the approach is really strategic litigation in these specific things, specific areas, to bring the government to book on high failure rates of these cases. There is also poor reporting or fear to report because of ignorance of rights. And it is the duty. We've signed many international and regional instruments. We are parties, and we are expected to, the government is expected to do something about it. And then when they tell you there's no money, and you see the wastage of resources by our politicians, so you're like, if they gave me that money, even though I'm a judge of the High Court, I could arrange to buy beds, delivery beds for my sub-county, buy this, buy that. So we need cases coming seriously, because resourcing of the police, mistreatment of victims by the system, police, medical office, the courts. I am not shy to say that the courts mistreat people. Nobody can do anything to me if I say it, even if I said it on TV, national TV. The courts mistreat litigants. We are trying to address it. It's an individual thing, depending on how polished a judicial officer is. Justice Batema here, and before he hears the case, that is now the gallery. The parties are here. In the morning, he starts addressing people about their rights. He starts asking who has a baby here, who is a mother who has a patient, and so on and so forth, so that he can prioritize the cases according to the individual needs of the people before him that day. But generally speaking, there's a lot of, and they say that he's just a wiseacre. He's looking for cheap popularity. Why would a wiseacre do that every morning if he's just a wiseacre? It is something that he has embraced, that he appreciates the reasons for, but some people claim he's just a wiseacre. He's not behaving like a traditional judicial officer. But what are you doing as a judicial officer if you cannot respond to the needs of the people that you serve? And yet you are being elevated, you have a very high position already. Why do you want to rub in the fact that you are so important? So the cases, we are waiting for the cases. You pray for all remedies, including the setting up of a transitional justice mechanism to remedy those who have not been received their right to remedy.
Thank you so much, my Lord. Justice Batema. Justice Batema.
Yeah, she has said almost all. I just want to take you to another angle when we are talking about the laws and what we should respect. Sometimes I read a law and I see emotions in the passing of the law. Let me give an example of aggravated defilement. Aggravated defilement was, first of all, introduced for cases of children below 14 years. When I read the Hansard, some member of parliament said, but we should aim at fighting HIV/AIDS. Anybody found to be HIV positive should be charged with aggravated defilement. So when I visit prison or when I see people arraigned before me with aggravated defilement, I try to look for the section. Under what subsection? And it is HIV positive, and I ask, were you aware that you were HIV positive before you were arrested? He said, no. In fact, we had enjoyed sex for 3 years. I wasn't aware. But the moment you are arrested, you are tested. Now, the government should have made the testing available free of charge. Not wait for you to be arrested so that your case is aggravated. I thought there was some emotions in that law. So when I'm sentencing, I use my discretion. I say, if you did not deliberately spread HIV/AIDS, I'm giving you a caution. Go back. Never do it again. And people say, what? Aggravated defilement? Sentenced to a caution? I say, yes. There was a lot of emotion. It is an emotive law. Look at a subsection which says anybody who has sexual intercourse with a person with a disability has committed aggravated. Then I asked, one time I asked in open court, is it true that disabled persons don't enjoy sex? So no, you can communicate to a deaf and dumb person and you agree on sex. And you even have children. Say no, that is aggravated defilement. Unheard of, shouldn't people with disability enjoy sex? Say, how do you tell that somebody wants sex? What sign language do you use to ask for sex? They say, use this. But that's lack of understanding when the people are debating. Both, this is sex. I don't know how you would do it in the Bachiga way. So, I think the court has a duty to continue looking at the laws that exist, whether they promote reproductive justice or they are punishing somebody who didn't even have a line in that. So one person who was disabled in Mbale said, he's my husband. All the men in the village had rejected me. He picked on me and said he's going to wed me. So if a man, straight, he called him straight man. If a straight man like that has picked on me in spite of being disabled, why don't I go with him? While the law was emphasizing disability, disability, disability. So as a court, as judiciary, we have a duty to exercise our discretion judiciously when we are giving reproductive justice and not merely punish as it is that every law must have a punishment, and sometimes they say not less than 10 years, not more than these years. I think sentencing should be left to the discretion of the judicial officer. I'll add on later.
Thank you, my Lord. Justice Mandala.
Thank you. I just want to add a small dimension to the discussion based on one case that I've handled so far. This is a woman, a businesswoman who went to our top private hospital in Malawi. And the doctor who was supposed to help her deliver could not pick calls. He was going somewhere for golf, and he had an appointment, new, and the child died because there was no one to help the very expensive hospital. And the Medical Council of Malawi investigated the case and concluded that the doctor was negligent. And then in their investigation, they also did 2 other cases that had happened prior to this particular case, where also the children died. So my point is this, that, you know, it's amazing that you'd think it's always about corruption and poverty, but even in private hospitals where people are paid huge sums of money, doctors, I don't know, they get desensitized over time. They think it's one of those things, but it's about people's lives. And, you know, so he came looking for a stay of the decision of the Medical Council that he should continue practicing while his case is being. And I wrote a judgment which I shared, I think, with Moses, where I said, no, I think in cases like this, you now have become a danger to. So let's wait until those processes are over. But the point is, it's not always about poor women. even in a public, private facilities where people are paying huge sums of money, you have cases like this. Yeah.
Thank you, my Lord. My next question is, how can Afrocentric jurisprudence address the unique SRHR challenges faced by marginalized individuals and groups? His Worship, Abubakar.
Okay, thank you very much. Marginalized individuals and groups, Afrocentric approaches. I will go for the children. There is a lot of chaos, if I can call it that, in our juvenile justice system. And for the case of Uganda, which is also the case for most of sub-Saharan Africa, the last census we had in 2014 told us that 52% of Ugandans were below 15. Just think about that. That means it's a country for children. Now, in a country for children, we have, are they now 5 remand homes? And now, like the remand home in Mbale, when they bring juveniles to court, we are even worried because you're going to get stuck with a juvenile. Now, enter reproductive justice. There is the cases of defilement that have been contested about child-to-child sex. And I've had a lot of challenges. And when my supervisor, sometimes we caucus trying to see what do we do. Number one, there's the element of poverty. So we realize most of the cases that reach us are those from juveniles or accused persons who are the poorest. If they have some resources, it will not reach court. So the moment you see them in court, just know they are the total fans staying alone on the street. Now, you keep insisting, you want to say guardian or parent, nobody shows up. You try to chase the probation officer, I don't have fuel, I don't have this. You want a report. You are stuck with a juvenile. Now, cases of defilement, and there's even one they brought to my court of aggravated defilement. The boy was 15, the girl 13. So the boy is charged with aggravated defilement and the girl defilement. And State attorney, what is this? How do I do? Yeah. What? So even the record for age in my district, there are no records for age. So the police has a mechanism of accelerating the age. If you're 16, 17, and then they say we handle juveniles with kid gloves, in quotes, so they accelerate it to 19 or 20. So you look at the suspect, and then even the voice, the reasoning, and this is a child. Now, I used to send them back. I used to trust the medical report so much. I think I'm dealing with professionals. So everyone I would send back, they would quickly come back with a form. He's 19. So at some point I got concerned and asked for the authors of these reports and tried to have an interaction with them. And I realized they don't do any serious examination. In fact, it's like the police, they just, so the court wants a report. What are the particulars of the victim? Well, and then a report comes. So now, you don't know whether you're dealing with a 16-year-old or a 19-year-old, and there are so many attendant challenges with that. Then where, because usually now like for child-to-child sex, when they are accused, the community believes that it is the boy who defiles and not vice versa. Now, the parents of the boys have also learned that, no, it's now two-way. So the family of the girl reports to police, the family of the boy also reports. The police arrest both, they bring them to court. A1, A2. They plead guilty. So, do you send them to, well, do you send them home? Do you give community service? But what kind of remedy? And then you send them home, what we usually do, and they are very disappointed. The parents and the community LCs, they come in the DC, saying, you're not helping us. And yes, they want cows, they are looking at this as a transaction, and even when the cows come, they are not for the victims. They are for the families. So, the question is, how can we, I'm not sure I have an answer, but practically speaking, what we have tried to do, at least in my jurisdiction with my supervisor, is to push them back to the community. And recently, we have now also started looking for the parents to actually instead arrest some of them, because they arrest the juveniles, they don't show up, you have no information, they're just, that girl is very difficult, you take her where, you are the parent. So I have like counseling sessions to explain to her, this is an adolescent, these are things, didn't you go through this, There are things that are happening, they have to, no, let her go to the remand home. Do you know where you're sending the child? So I really don't have an answer, but I think that awareness and constantly asking and probing some of these practices helps, but I'm also aware that not all of us use these approaches. So in the end, many times it ends up with passion. Some of us are more passionate than others on particular issues. So you may do forum shopping. I don't know. But ultimately, because your question was general on vulnerable groups, but for the case of Uganda, I think we have some work, a lot of work to do around juvenile justice. In the real Ugandans who are the children, it's their country. We need to, and the laws are quite progressive, but there's a lot of ignorance about the law. There's a lot of negligence from the parents and community, and of course, things like poverty make it difficult. I end up with the final one. I underwent a training where I had lordship was one of the presenters, and they enlightened us as magistrates about the empowerment we have in the Children's Act to release a juvenile on bail, one accused of any offense, unless, of course, their life is endangered. Now, currently, we have one of us, a colleague, who is actually undergoing some disciplinary action, allegedly for acting above his jurisdiction, because he released a juvenile accused of a capital offense, aggravated defilement. So, for me, it's just ignorance in emotion at different levels, you know. So, yes, but that case for me demonstrates the level of ignorance. So many times I've taken it upon myself, to call police and say, these files, please don't put the names of the juveniles on top. This one, please don't call them an accused. Don't do this. The victim, don't bring her in open court. But you realize it's like nobody's aware of these things, Yeah, so training and awareness maybe is what I can say, but they are difficult questions.
Thank you so much, Justice Mandela.
I think I'll go back to what His Lordship said, Sister Batema, about us looking at the laws as we find them and, going back to our Constitution and see what we can do to deal with the situation using an expansive approach of interpretation to deal with challenges that, we are currently facing. Because, let's be realistic. It takes so long for our countries to review a law and to pass it. And so we can't just, sit back and say, well, until Jesus comes. Let's do what we can with the powers that we have and use expansive approach of the laws as they are to still address the challenges that we have. For me, I believe that the concept that we learn in constitutional law, that a constitution must be a living document, it's not just the constitution, but I think even the statutes, they also must be, living documents that help us meet challenges that we are facing now. So that's the approach that I would take. Just to add that in Malawi, we have a case where some families are challenging a law that criminalizes sex between children or less than 18. Because the thinking is that when this law was being promulgated, the intention was never to criminalize children. Precisely. It was to criminalize adults who take advantage of children, not children themselves. So I'm sitting on the panel of the Constitutional Court, and one of the first things we did was to invite amicus to help us. And so, being, activist, pragmatic, we invited everyone who wanted to join the case, including Center for whatever in South Africa, UN Special Rapporteur on, and so the Attorney General didn't take this kindly. So they got a stay from the Supreme Court to say that some of the amicus were not comfortable with. Oh, this is a domestic issue. I'm like, so we are stuck because we are still waiting for the Supreme Court to resolve that aspect. But I can share the ruling, which I did on that point, in admitting amicus, and we'll see what the Supreme Court is going to say. But the point is, it's being challenged because we think it's being abused. It was never intended to criminalize children below the age of 18. Thank you.
Many thanks, my lord. The next question is, how can Afrocentric jurisprudence navigate the coexistence of customary laws, religious laws, and statutory laws in order to create a harmonized and right-based approach to sexual and reproductive health and rights? Justice Chairman.
Well, I think we should involve the local communities in all these processes. The Ugandan Constitution enjoins the judiciary to administer justice on behalf of the people. So the judiciary has a duty to call on local communities and get their views on many of the processes they carry out, including issues of procedure that were talked about this morning. In Uganda, our courts have what they call stakeholder users meetings, where on one of the days you call all the stakeholders to come on a round table and discuss all the issues without limitation. Of course, you don't touch on matters that are in court already. But the few I've participated in over time, I have not seen the academia participating. They are the people who have a lot of knowledge, but they don't bring this knowledge on the table. In Uganda, I think their interest comes in only when we have a presidential petition. They come in and say, now we must give our views here. But I think they should be available most of the time. And this goes further even to legislative processes. Participation of the public, of communities in enactment of laws is very important. The only lacuna there is that we do not have specific laws how this is done, but it is a requirement that people are allowed to participate in these legislations. So to me, if this is done, it will help in bringing out understanding, agreeing on how to move together, and it may be one of the ways of navigating through this.
Thank you so much, my Lord. Justice Batema.
How do we
create a harmonized rights-based approach to sexual and reproductive health and rights?
That's creating space. That's creating a table where we can discuss from. It's much like a home. There is a father, there is a mother, and their children. How do you come to a round table? Should we listen to the children, or we are the master decision makers, master planners? As we deliver justice, as Honorable Justice Cheborian has said, we deliver it on behalf of the people. Specifically in Uganda, Article 1 of the Constitution says, power belongs to the people. Now, the people doesn't say women, men, or children, the people. Then in Article 2 says the Constitution is the supreme law of the land, and it is, if there is any other law which is inconsistent, the Constitution shall prevail. The other law shall be not null and void. It shall be void to the extent of the inconsistency. Meaning that if it is a mango and one side is rotten, you eat the other side which is good. Right? So discussing how to eat this mango means that we be open. Be open and do what the parliament, what the Constitution has told the other bodies to do. Let's teach, let's impart knowledge onto our people about the constitutional rights and say this one is allowed under the Constitution, this one is not allowed. This one we have signed under international law, but our Constitution doesn't bring it out clearly. And this law, if we done this way, it won't work. It is our duty as judicial officers to get out of the cocoon of the courtroom where we bang tables and people stand up. We bang tables and that's the finality of it. No. Let's be in a space where we are able to be asked questions. When I was chief magistrate and I'd just come back from Zimbabwe in the year 2000, I began a program on a local FM radio. And the chief registrar then is now Supreme Court Justice Musota said, how will you answer questions of people who are calling in direct? And indeed, it became a problem. One caller said, hello, Batema, you are all corrupt. What are you talking about? And I had to say, look, there is white and black sheep. It's not good to say we are all black sheep. Point out which sheep is black, which case number, which court, and you'll be helped. Some of us don't consider ourselves as corrupt as you think. Right? So we should go to these open forums where we have to meet the people. When I was Registrar Family Division, I had a program in Rakai. Rakai is where HIV/AIDS was discovered from first. And we were initiating male circumcision as a form of prevention of HIV. And we were being used as the specimen. So we coined the language of responsible men. We would go to the market, Saturday market. These are weekly markets. And to look for the men, the registrar had to go to the wing where the men are taking local gin, waraji and tonto. You buy a jerrycan and you initiate conversation. That was Rakai Health Science Program. And everybody was saying, oh yes, now we understand it better. We know why so-and-so was in prison. We know why so-and-so was released on bail. So where do you find these people who need the information, who need the data? We had to involve various stakeholders. We recruited some Catholic priests in a program called SHARE, Safe Homes and Respect for Everyone. And we are talking about domestic violence. And we are using the priests to preach love against domestic violence. And one priest came up with the story of the wine, that Jesus made the best wine at the end of the marriage ceremony. So as you grow old, make your love lovable. We loved such things. So can we be creative? Some of us are artists. Me, I'm a film actor. We are good dancers. We are good musicians. Why do we limit ourselves to this cocoon when we can use our talent elsewhere? In 2003 to 2014, I asked to be a part-time lecturer at Makerere. I was told law, gender and the law is full, but you can be a lecturer at the School of Women and Gender Studies. I went there and introduced the syllabus, gender and human rights, gender and the law, gender and the practice in Uganda. And I've got so many graduates. You walk along the road, someone says, oh, you're Musome, that was my teacher. I said, no, it's his lordship. You first load him. So they load you, but they say, I am your teacher. See how teachers are very proud. I think we have to use different forums to teach the law. I'm a member of the Central Usoga Diocese. When I'm invited to talk to the church, whether it is preaching or greeting the people, I pass on a message, and they know that I will not stick to the Bible. If I stick to the Bible, sometimes I throw their barbs. And the bishop says, that is a representative of the community. Those are the Christians we are preaching to. So when they hear it from a judge, a male, they accept the opinion. The people accept the opinion. So for me, I think it is our duty to give substantive law to our people, give skills to our colleagues in maybe judicial fellowship. How come we meet as judges or magistrates and the judge is unable to give out his phone contact? How shall we develop judicial fellowship? Maybe somebody is bothering with a small thing and just wants to consult. They says, hello, Justice Batema. Oh, don't worry about loading me, my lord, my lord. Just say, Batema, oh, Sister Batema, if such and such a case comes, how do we handle it? But as I said, we need to to teach our people how to exercise judicial discretion affirmatively, where the laws are not enough, where the circumstances are peculiar, so that each case gets its justice as it deserves. I want to end by saying, as judicial officers and as lawyers, we need to do research. We need to do researches, involve ourselves in studies, so that we talk from an informed point of view, with data, with informed examples. Get a paper like this from Shokoro and talk authoritatively wherever you are. Let us not talk like journalists. Sorry for the journalists. When we are talking law, let's talk what? Law. The journalists can pass without quoting a case, without maybe differentiating it, but when we talk from an informed point of view, with studies, with data, empirical data, we shall be able to, for example, dismiss corroboration. What empirical data do you have that women tell more lies than men when it comes to sexual offenses? So I think it is our duty to continuously educate ourselves and then share the knowledge. Put it online. Invite criticism, invite comments, and we shall be there. Thank you.
Thank you so much. My time is up. So I would just ask one last question. How can Afrocentric jurisprudence challenge societal stigma and discrimination towards individuals who would like to access sexual and reproductive health rights and services? Justice Batema.
Stigma. You know, stigma comes from those with authority, stereotyping. Say, for example, all men are strong. And so when you speak in a weak voice, say, speak like a man. Hey, who told you all men can speak like men? We had a president here who said, "Hi, President Rule, so in the name of..." Hey, was that speaking like a man or a woman? So if we want to fight stigma, we first fight stereotyping. What is good for the male, what is good for the female, and then we make it cross-cutting. I said we can begin with language. We can all go to dogma and the rituals, so that what is applicable to men is applicable to women. And once you are in a position of authority, make your opinion known. It will be valued. I once shut down a preacher who was preaching against women wearing trousers. I said, "You're wasting our time this Sunday. There's nothing natural about wearing trousers. If you can't afford a trouser and my wife can afford, please leave us alone. We are talking about spiritual matters." Yes, so we make our opinion. Yes, let's make our opinions known. And when we are in respectable positions, this stigma will die down. Abortion, people say, you see Vatema's daughters going up to university and graduating. They must have committed abortion. I say, I don't want to know whether they committed abortion or not. I'm happy they have got the degrees. And then people begin saying, that man doesn't mind about. Now we have particular people we have to address. Those who are propping patriarchal attitudes, male chauvinism. Bishop, me as a member of the clergy, I talk to the bishops and I tell them, excuse me, some of you are missing out to becoming bigger people because you committed adultery. But if you had committed an abortion, who would have known? But these things about sexuality, whatever, they don't know your flocks. They lift the veil. Ntagali ya tagala. No. Whether you're of whatever faith, let's talk about sexuality as sexuality. And let us not mix up the issues. So let's tackle
those who have power. I was called one time to deliver a keynote speech at Imperial Royal, and the chief guest was the First Lady. And I gave a nasty example. I said, as we are in this room, we are all opposed to abortion. People clapped. I said, I can't imagine the first daughter of this land being abducted by Konyo of the Lord's Resistance Army, and she comes back with a child of the enemy. The room went silent. I don't want to repeat it. But when you talk to the powers that be, you are telling them, keep quiet or join us. Give them the information. Give them the data. When there is researched data, people begin thinking twice. The stigma will go away. Lastly, perhaps I would say, when you are in those communities of yours, much as you reduce yourselves to the levels where you can participate in talking to them, remain smart. Remain what? Smart. Yes. Say, who is talking? Say, the other one. Smartly dressed and is advocating for abortion, safe motherhood. Maybe we should use some language which can bring in people. Can't we create words? We people here, are we short of words? If the musicians have coined words in Uganda, bada, chichupuli, what? Can't we create words for abortion? If abortion sounds so bad, let's call it what? Topping. Termination of pregnancy. Ono omusajja yagambye agenda kutopinga olubuto lw'omwana oyo. And it passes smoothly. Thank you.
Thank you so much. Thank you, my lords. Thank you, worship. It was indeed an insightful session. I think you all will agree with me. Sorry, 1 second.
Certainly, all this is a work in progress. It's a continuous process, and I don't think we should be expecting results so quickly. But what I wanted, they will come, but what I wanted to say is the issue of descending into the arena, which touches on issues to do with the perceived or actual bias. As much as we are judicial officers and we are free to do this, we must guard against people thinking of us that we are now on this side of the story. It is important that we should be seen as being, as much as possible, being neutral and in the middle, in order to remain with the integrity to decide matters. That would be my view.
Thank you so much. Thank you. Okay, fine.
Confessions or testimony? Yeah, so I just wanted to say, to answer the question, that last question, on how we can create harmony, I agree with His Lordship that we need to sensitize, but I also want to add that can partly be leading by example. Somebody said the leading by example is not the best way of leadership, it's the only way. So sometimes, like in my community, when I go to Bududa, I make sure that I use my story to add, without necessarily directly saying reproductive justice or abortion or what. I just use my story. So for instance, my mother conceived me while she was in S4. My father, they were in the same class, so they didn't listen to their teachers and parents. They did bad manners, as they call them, good manners, and my mom conceived. And so she, because I think there was a relationship with my grandmother, her mother, she communicated. And my grandfather, expectedly, a teacher, was very tough. My grandmother must have known that if he finds out, my mother would be thrown out of the home. So they colluded, if you will, and hid the pregnancy from my grandfather. And the first time he found out was a cry of a baby in their house. My grandmother was the midwife in the house. So on the 9th of September 1990, 8 p.m., there was a cry of the baby in the house. And the man had long since stopped. There was no known pregnancy, so he walks and found the baby. He could not strangle the baby. The baby had to be embraced, and the baby is now a magistrate in the court of law. So, for me, for my community, when a girl gets pregnant and she's at school, I will not argue through theory. I will tell you, I was conceived in those circumstances and I'm here because she went back to school and also finished school. So when you say a girl who conceives can't go back to school, if even you, the family, you're contributing to the stigma rather than cancel her, and support her, because my grandfather was also recruited now by my grandmother. They supported her, looked after me. She went back to school. I also studied. So don't you want a magistrate? Thank you.
We do. Thank you so much. This brings us to the end of our session. Thank you so much.
Thank you very much, Your Lordships and Your Worship. I think the panel has done justice to the topic they were requested to discuss. Two things stand out for me. The issue of context. Every case should be decided based on its facts. And also the emphasis of the independence of the judiciary, whereas they act as checks to judicial and parliamentary power. They need to be seen as neutral. And finally, I think the essence of this space, this litigation baraza, is to encourage such conversations between the bar and the bench activists from all perspectives. And together we can chart contextually resonate strategies for advancing sexual reproductive health and rights for Africans. So our next session will be after Mr. Bamidele Jacobs from Nigeria helps awaken us with a simple exercise. So Jacobs, you're welcome to help us stretch and prepare for the next session.
Thank you. I think it's just going to be a simple one. I'm going to go the way of my army professor. But this time around, no, we're going to do it on our seats. So I want to do a practical demonstration. That's why I want to be here. So what we're going to simply do is to stand and go down on our various seats. I demonstrate that. We're going to keep doing this with you. Yes. We're just going to do it for maybe, let's begin with 10 times, then we'll do 20. That's how we do it. Are we all ready? Let's go now. At the count of 3, okay? Maybe I should use this one. At the count of 3, we're going to start. Are we ready? Yes. 1, 2. Are we ready? Yes. 3, go. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay, we're going to do the second round. 20 this time around.
Thank you, Jacobs. Thank you, Jacobs. Thank you, Jacobs. As you can see, thank you. The team is awake now. So we will have a final discussion. Dr. Maria Nassali is supposed to be presenting a paper on abortion cases and inclusiveness on African jurisprudence, but she conveys her apologies, and she is going to be represented by Miss Julia Kemigisha, who is a lawyer and an advocate for women's rights, for which she's very passionate, and she works with the Women Pro Bono Initiative in Uganda. Miss Julia, you're very welcome. After Miss Julia, we can have a plenary session for just a few minutes for those who would want to make any few comments, if they exist. So Julia, you're welcome to take the stage. Her presentation won't be long. Good afternoon, ladies and gentlemen. As I've been introduced, my name is Julia Kemigisha, and I'm honored to present Dr. Nassali Maria's paper on abortion cases and inclusiveness of African jurisprudence. I will begin with the definition of reproductive health by the ICPD Program of Action, paragraph 7.2. It implies that people are able to have a satisfying and safe sex life. People are able to choose when and how often to have children, and the freedom to decide. With this definition, we recognize that the only person who can understand the changes their body goes through in the process of pregnancy, childbirth, is a woman, and thus the choice should be left to her. The focus of this paper, among the various reproductive health rights, is abortion. Abortion is a contentious matter. However, the conflict surrounding it does not take away the fact that it affects not only women, but our society at large, individuals, families, and everyone. In Africa, abortion has been branded as un-African. Because its existence in the pre-colonial Africa is debatable due to the fact that the oral nature was probably codified by the patriarchy. But despite viewing abortion as un-African or alien to our society, this does not necessarily take away the fact that it actually happens. According to statistics, 97% of abortions that have taken place in Africa are unsafe, and 15% of pregnancies end up in abortion. This shows that denying its existence only aggravates the rate of maternal morbidity due to unsafe abortions. Abortion laws in Africa vary from country to country, and it is essential to review the few cases that have happened, in order to draw lessons that will in the long run protect women's reproductive health rights. I'll look at cases from South Africa, Kenya, Malawi, and Rwanda. Beginning with South Africa, we know South Africa to have the most progressive laws due to the fact that its constitution expressly provides for bodily autonomy and a right to reproductive health services. It also effected the Choice of Termination of Pregnancy Act, which doesn't restrict abortion in the first trimester, and thereafter it is permissible with consultation. Now, the cases in South Africa will look at the Christian Lawyers Association versus the National Minister of Health and Attorney General of 2004 and 1994. So these cases highlight the controversies surrounding abortion, particularly on the legal status of a fetus. There's always conflict in abortion cases due to religion, moral standards, and societal beliefs. Among the controversies that were seen in these cases were the indecision as to when life begins, the rights of the fetus vis-a-vis the rights of a woman, and how government treats the issue as an issue of morality, but civic spaces say that it is due to the lack of health guidelines that we still have unsafe abortions in Africa. Now, the essence of the two cases of the Christian Lawyers Association was to show how South African courts emphasized that one gains personhood, that's being recognized as a person, or legal status after being completely extruded from the body. It would be unfair to impose criminal sanctions in law that force a woman to endure the process of pregnancy, childbirth, against her priorities and aspirations as any other normal human being. There is need to balance the right of the unborn and the right of a woman, who should not be forced to experience bodily changes against her will. The Christian Lawyers Association cases further examine the fetus rights vis-a-vis the woman's rights. The issue was whether a fetus has rights, and here court stated that circumstances should not be based on science, or the decisions of court should not be based on science or logic or morals or personal beliefs, but rather they should study, and it should be a matter of proper legal interpretation. The legal interpretation of these abortion laws suggests that a fetus only gains legal recognition when completely extruded from the body. Thus, it cannot be placed above the woman's rights to health and bodily autonomy. Now, despite the successes of these cases in putting forward the woman's rights, there is a point where there is a deflection from the bigger picture, which is the current focus of women's reproductive rights. They tend to look at the question shifts from women's rights, and it goes to the importance or the status of the fetus. And they fail to answer the actual question of whether these women's rights are being violated or not. Another lesson drawn from the Christian Lawyers Association cases, particularly the one of 2004, it amplified the issue of informed consent, especially for girls under the age of 18, who require parental guidance and guardians. Court distinguished between the common law rule of consent, which requires one to have parental guidance, and actually talked about considering the emotional and intellectual ability in the capacity to consent. Here they looked at the fact that with the current time, people's mental capacity, people's ability to process and to understand is not necessarily what it was before. And therefore, there is need to consider that in their capacity to consent. I'll move on to the Kenyan cases. In Kenya, its law on abortion is in respect to both upholding the health of the mother and to save the life of the mother in case of danger. Even its Article 26(4) of the Constitution highlights the acceptable parameters for abortion. In Park and Salim Mohammed versus Attorney General, it was held that court considered the cruciality in holding the government accountable to not only uphold its negative duty in refraining from interfering with women's rights, but also to uphold its positive duty in ensuring that these rights are realized. This, of course, would be government's part to put in place guidelines, to put in place acceptable policies that will be able to guide the parameters that have been allowed for abortion. Also in the FIDA Kenya petition, it was held that it's not enough for government to refrain from interfering with women's rights or private life and bodily autonomy or even decriminalize certain cases of abortion without instating guidelines to realize these parameters. That is why by government withdrawing the training guidelines of 2012 and stopping the training of health workers, it not only rendered Article 26(4) a dead letter, but it also interfered with a realization and actualization of women's rights, especially to the safe abortion. In another case of the Coalition for Reform and Democracy versus the Attorney General, they studied the limitation of fundamental human rights. We know that in order to limit certain rights, this has to be done in a manner that is reasonable and justifiable in an open and democratic society based on human dignity and freedom. However, we learned that the decisions to withdraw the guidelines on reducing morbidity in Kenya did not meet the three-part test of being permissible, reasonable, and justifiable, because it left a void, it left uncertainty and insufficient guidance on how they should actualize the parameters that were permitted for safe abortion. I'm going to look again at the FIDA petition because it was very pertinent in drawing out a number of lessons. So this petition also brought to light the conflict between women's rights and healthcare professionals' rights. While a woman is entitled to access these services for safe abortion, the healthcare professionals also have the right to conscious objection. Therefore, as Professor Ben had discussed, they can decide whether to take on the case or not, only if it's not an emergency. So in such circumstances, the right to conscious objection by health workers should not be used as a way of limiting women's rights. It shouldn't be used in a bad light, or it shouldn't be used to obstruct women's rights to health. Rather, it should be exercised judiciously. The impact of this conflict, however, increases the rate of maternal morbidity because a woman is left uncertain on where to access these services, and in cases, and it also increases the stigma and increases the fear, because if healthcare professionals have this opportunity or have this right to conscious objection, there are very few choices left for a woman to seek safe abortion. It's also emotionally, physically, and mentally detrimental to her health. In Rwanda also is progressive because it also allows for both protecting the woman's health and also abortion in cases of saving the mother's life. And it broadened its circumstances by removing its reservation of Article 14.2c of the Maputo Protocol in 2012. This not only expanded the parameters for safe abortion, but also it shows how the Maputo Protocol has shown incremental progress in advancing the right to countries where abortion was totally illegal. That provision in the Maputo Protocol opened up gates, and it also it reduced on the rigidity of considering the parameters for abortion. So in this Rwandan case of in the High Court at its headquarters, tried in the presence in a public hearing, where a 13-year-old was defiled and denied termination of pregnancy, court considered the best interest of the child and granted the request to abort, since it would be emotionally and mentally damaging for the young girl to be forced into motherhood, especially because of the shame it would bring to her among her peers and her aspirations. We see that the acceptance of Article 14.2c of the Maputo Protocol has a positive impact in broadening and reducing the rigidity on the limitations and accepted parameters for safe abortion. Malawi, on the other hand, only permits abortion to save the mother's life, just like Uganda. Uganda and Malawi also placed a reservation in Article 14.2c of the Maputo Protocol, and this has continued to aggravate the rates of unsafe abortion. Citing the Malawi case of MM versus Queen Elizabeth Hospital, where a 13-year-old was denied abortion after being defiled. They based this decision on many circumstances, but the ones that stood out was the fact that the abuser was the one in charge of giving her financial assistance. There was a bit of patriarchy. Then the court also found her reasons to abort out of the accepted parameters, and that is to save life. Here, we imagine the distress of this young girl, 13-year-old, who has been robbed of her innocence in the first place, but is now also forced into early motherhood, unprepared mentally, physically, and emotionally. In order to harmonize all these controversies and contentions about abortion, we need to revisit the aspect of Ubuntu. Ubuntu is an African philosophy which focuses on shared humanity, togetherness, and compassion. It also embodies justice and fairness, and particularly substantive justice that considers the surrounding circumstances. Abortion, of course, has evolved over time from permitting it only to save a mother's life. Now we're at the point where it's permitted to considering the plight of sexual violence victims, and therefore it shows that there are a range of circumstances that may prompt a woman to take that decision. Women's struggle for autonomy stems from the large struggle of equality and justice as women. Therefore, we need our society in Africa to place themselves in women's shoes when making these decisions without harsh judgment on what could have prompted a woman to take that decision. Taking into the circumstances that place women in need for abortion services will enable the African society to deal away with criminalization and stigma on abortion, and instead enhance efforts in empowering women's autonomy, in reducing maternal morbidity due to unsafe abortions. Thank you, ladies and gentlemen. Exhausted. So I beg that you keep those questions that you have regarding this discussion, and maybe we can catch up on that tomorrow in the morning. So for now, I will thank you so much for being very active participants and for involving yourselves in such intellectual discourse. We have tea served outside where we had our break tea in the morning, and then at 7 we will have a group dinner at the same place. So thank you very much. You can rest now. Thanks. See you tomorrow.